Debtor is entitled for interest on the refund amount from the date of making payment of IGST on ocean freight. If not paid within 8 weeks from today, it will carry 9% per annum. It shall dispose.
Test admission item number 2.
Number 55.
What you were doing, why you did not mention the matter before the list is gone? Baseless.
151A is not followed.
So we have already,
This matter on.
no, we have already displayed.
Four.
Item 4 pertains to cancellation of electricity.
Cancellation. Item number 5.
It has not taken up.
Disposed of by the Supreme Court.
No, man, the book is 27 January. 27.
Item number 6. Item 7.
This is a case where the Commissioner Appeal has sat in judgment over his own predecessor's judgment, where the Commissioner Appeal has already held that I was eligible for drawback. He records that the Commissioner Appeal's order has been accepted and becomes final. Yet he sits in judgment and says, I will disallow the drawback. Let's just see the order which has been passed by the Commissioner Appeal, which is an appeal before your, which is a challenge before your lordship. Page 45 lordship. 5.3. 5.3 on page 45. I read that topic, page 45. I find that the instant drawback claim was sanctioned after the decision of the Commissioner Appeal, Bhubaneswar, by order and appeal dated 30th September 23, wherein the party has been allowed drawback of rupees 162 crore in respect of 4 bills of export, subject to the condition of reversal of ITC.
PST Center Electrician Custom
Order and appeal dated 30th September. The Commissioner Appeals has also taken the view that interest should not be levied on the reversal of ITC, as availment of credit of CGST and IGST is quite lower than the drawback claim. The order of the Commissioner Appeal has been accepted by the department on 18th December 23. No appeal has been filed by the department against the order and appeal dated 30th September 23 issued by the Commissioner Appeal. Accordingly, basing on the said order and appeal dated 30th September 23, the instant drawback claims have been sanctioned by the Assistant Commissioner Bhubaneswar by order dated 24th January 24. But while sanctioning drawback, the original authority has adjusted ITC of 40 crores along with interest of 45 crores from the amount of drawback. Now, Lordship, this is the finding of the Commissioner Appeal. I observe that the order dated 30th September 23 of the Commissioner of Appeals is incorrect. Insofar as the direction should have been to allow drawback only if no refund of GST ITC was taken. If at all the refund of ITC was taken, the same should have been paid back along with applicable interest before applying for drawback. The decision of the Commission of Appeals to accommodate the reversal of ITC by allowing adjustment of ITC from the drawback amount is illegal, since the ITC is a concept under GST, whereas drawback is to be paid under the customs, and there is no provision under either GST law or the customs law that allows the adjustment of payment between the two acts. Then para 5.4. I find that the reviewing authority has relied upon circular of circular number 23 and 24 to drive from the point that drawback cannot be allowed wherein input duties have been neutralized by way of ITC or refund to the claimant. In view of such circular, I find that there is no ambiguity as regard intention of the government. Hence, drawback should have been sanctioned only if no ITC was availed, and if ITC was availed, then paid back along with interest before drawback was applied. In this case, I am of the opinion the SSC has made concerted efforts to avail two alternate benefits at the same time. They are reversing one of the alternate benefit only when the same is noticed or apprehended by the department. Such actions are not expected from a company of repute or Vedanta Limited. In the instant case, as they've already availed ITC, I hold that they're not eligible for drawback. As they're not eligible for drawback, the question of interest does not arise. Now, this is the order of the Commission of Appeals, Lordship. When already his predecessor has...
Then he has to refer the matter to...
No, he has to file appeal before the.
No. If
Sister.
if he want to
He
take
has
a
to file
dissenting
appeal.
view,
No.
Before the government of India, Lordship.
राधा स्वामी पर से अरब फाइनेंस कंपनी का कौन राधा स्वामी for finance key finance you have to respect Justice Ranganath Mishra's judgment in OFDC जो OFC Odisha finance
Yes, Lordship, sir, given this
Excise.
Oro Global, Lordship, sir, they can have...
you have to respect the appellate order quasi judicial authorities order. How can you sit over that?
No, only course open if you have a doubt, you could have raised that particular doubt and send it for any other action to be taken. But you can't take a dissenting view. The committee of the discipline which requires a uniformity and the certainty in the decision, you may have some views. You just say, or what we are doing. If we are doubting any judgment of the coordinate bench, we are referring the matter so that the larger bench can constitute or a third bench will decide.
Lordship, this is exactly the issue what Lordships have held in the case of Oro Global. This honorable bench has passed that.
But you can't defy the order of the court of your coordinate officer, and that is accepted by the department. It is not that the department has not accepted.
What
instruction?
He clearly says that he has not preferred any appeal before the that order stares at you. Still, then you are saying that he. And can you take to that position that appellate order?
The appellate order, Lordship, starts at page, Lordship, the order starts at page 47. The discussions and findings are from page
Not required.
Because
77 onwards.
elucidly given
Yes.
that yes, it has been allowed. This drawback concept is under the Customs Act. How can it be applied under the GST? It is either to be refunded or.
Page
Yeah.
77 onwards are the findings, Lordship, of the company.
Display, but you have to refer.
Oro Global is our judgment.
Lordship is looking at Oro Global, Lordship.
Yes.
Lordship, in Oro Global, in para 4.9 is the discussion on lack of jurisdiction in such an event where only as a subterfuge, the revenue in the garb of a review wants to not give effect to the order of the appellate authority. And thereafter, Lordships have discussed the principle of res judicata, which
Yes,
is what is
Kamalakshi Finance.
Kamalakshi Finance. And Lordships have discussed Odisha Forest Corporation and Kamalakshi Finance, both Lordships. In para 4.16, Lordships.
BSNL Justice Rumapal's judgment
Yes, Lord. The
with
principle of
regard
res
to
judicata.
consistency in approach. You can't.
It's the same, very same drawback which has been sanctioned when it went for disbursement. What happened, Lordship? The Commissioner Appeals said that you are eligible for drawback. Some verification had to be done with the lower authority. The lower authority had to verify and disburse the money. Against that disbursal order, they filed an appeal before the Commissioner Appeals, wherein this order, which is before your Lordships, has been passed, saying that you are at the threshold itself not entitled to the drawback, which could not have been done when the order of the initial Commission Appeals order has been accepted. That is the only plea, Lordship, that we are making. And that is why there is a complete lack of jurisdiction, Lordships. Lordship,
Let it come.
What come? It's a pure question of law. Facts are undisputed. No, I'm asking you, sir, it is an undisputed fact. Everything is there. He himself is writing, yes, this order is staring at my face. This order has been accepted by the department. Everything is set at rest. And then he reopens a dead letter. How can he do that?
If error creeps in, you are not remediless. That is what my lord is saying, that if you have recourse under provided under the statute, even now against the assessment order, you are competent to file appeal. Earlier it was not there, but now how will you justify? After
Very difficult,
admitting and
very difficult now appeal because they have accepted the department,
Yeah.
accepted and processed everything.
now there is a remedy provided under the statute.
So that was available to him
That-
before acceptance.
Yes, before
Once you have acted upon it, then what remained?
you have committee of commissioners to decide whether to appeal or not to appeal before this statute. That also has been settled. Court number 5. Mr. Prushti, I think he was arguing a lot in one of the matters.
Can't.
You go through this.
Yes.
Unnecessarily, what a
We'll
kind of case.
close.
Unnecessary. It is an open and shut case. What more?
Dispute.
Yes.
much obliged, Lordship. Much obliged.
Item number 8.
Dispute.
No, don't dispose of. Tell him not to dispose of. We are not recording. To keep it for orders because we have to leave this right good long judgment on the committee principles.
Conclude.
Obliged, Lordship.
Item number 8.
Can I break for a moment before starting of my line of claim? Your Lordship has a preliminary objection in this case. Still, the preliminary objection is still hold good to your Lordship. Your Lordship, I kindly come to the prayer, page 11. He has prayed to quash the adjudication orders dated 18th April 2024 and 21st April 2020. Page 11, your Lordship.
Yes.
2024, and the writ has been filed in 2026, and these orders are appealable, your Lordship. Yes, in order to outdo the delay.
That matter is concluded.
In fact, on that date, we could not understand at last that whether concluded or not concluded, I think.
No. Further argument is not invited.
Your Lordship,
Other matter. There's GlaxoKill matter. I think everybody has completed. Is in the process of a judgment.
your Lordship,
We are keeping it, adjourning it for 2 weeks. In the meantime, we'll definitely.
your Lordship. Or else
A preliminary objection is raised by the
On merit I have case, but since.
The preliminary objection is raised by the
Set to remain present.
Whether all those, only on that issue, your lordship judgment has been reserved, but all the other issues, because we have not filed counter, so far as the other issues are concerned. If, for majority, your lordship, if it is accepted, your lordship is going to accept the contention. Your lordship.
What do you think? Why you have a doubt?
No,
We know what we have to do.
And I am confident on myself, your lordship.
Yes.
I am confident on myself and on my argument.
So that's all. We will consider,
Yeah, get-
we know how to do.
Grateful, your lordship.
Item number 9.
May it please lordship, in this specific case, relating to the challenge, the legality of the notice issues are under 148 ALU. So the only difficulty is lordship is difficult to withdraw the petition by mistake. We have failed to the order of accession in the fair extent. That's
By-
filing memo.
That's it is submitted by the counsel appearing for the petitioner that the instant writ Yes.
Item number 10.
This 7 people. 7 people.
All matters.
I have mentioned that. I have mentioned the council's mentioned. But corrected in this.
Yes.
Item number 11. Let's see, one second, number 11.
Please, Lordship. Lordship, if facts of this case, petitioner is engaged in the construction of roads, Lordship. Petitioner support with an assessment order, Lordship. Against the order was passed without hearing the petitioner, Lordship, without considering submissions. That is the reason petitioner has filed the application for rectification, Lordship. That application was also rejected, Lordship. Thereafter, petitioner filed the appeal before first appellate authority, challenging the order, Lordship.
Which order?
Challenging the order.
The parent order or an order rejecting a rectification application?
Lordship, in the GST, the original order has to be challenged, Lordship.
That is what I asked you. Both the orders are, I think, the appellable.
Yes, sir.
Then,
The appellate authority, Lordship, they considered the date of the original order and said that appeal was filed after 3 months. Therefore, it is it's by limitation, accordingly dismissed the appeal, Lordship. Lordship, the order.
if the statute does not provide the power to condone beyond the outer cap, can he exercise such power?
Lordship, in this case, the rectification application was filed within the.
Does it really extend the period of limitation?
Lordship, since the order original passed without hearing the petitioner, without considering.
Whatever, can you do it? I'm just asking you. Once the appellate court, forum has said that outer limit you have already crossed, he does not have the power, then what to do? You know the Katinov decisions of the Supreme Court in a different statute as well.
Actually, the petitioner bona fide pursuing the same remedy before the adjudicating authority, Lordship. This,
I can understand if you take an advantage of section 14 of the Limitation Act, but that is not the correct one. You have to satisfy that you moved to the wrong forum. But rectification was a proper forum. It is also provided. Can't be said to be a wrong forum. That right emanates from the statute.
yes,
Then
Lordship.
section 14 advantage you cannot take. Then what remains, sir?
Lordship, the adjudicating authority, Lordship may take Lordship a couple of this.
Sir, two different fields altogether. Adjudication process is completely different from section 161 petition. Each order or decision is amenable to appeal. It is
Had
an
it been-
independent.
Had it been a case that the
statutory remedy.
rectification is allowed and something is rectified, then the original order gets merged, so there is no difficulty in this regard. But here your application was dismissed. Then
Lordship may be permitted to take Lordship in a couple of decisions, Lordship.
give me one decision, sir.
Yes, Lordship.
Not couple, even one decision.
Lordship, I have filed the memo of the decision.
That the appellate authority can condone the delay even beyond the outer limit which is set forth in the statutory process. I will be very happy to accept.
Lordship, the Honorable High Court said, since the petitioner is pursuing the rectification application, the date of rectification order shall be considered for the purpose of calculating the time limit for filing the appeal before the
Supreme Court,
High Court's Lordship.
which High Court?
Lordship, I have enclosed a couple of Madras High Court decision and Punjab and Haryana High Court.
Single bench or a division bench?
Madras High Court decision single bench, Lordship. The Punjab and Haryana High Court decision is divisional bench, Lordship. Lordship, all-
But it is contrary to the Supreme Court judgment.
Lordship,
Then which one is binding on us? Article 141 is the Supreme Court law declared by the Supreme Court is binding on us. They may have a persuasive value but not
Yes,
binding.
Lordship. Lordship, the original order is also passed without hearing the petition.
I understand that, but can it be done, gone into?
The order is also now challenged before Lordship. The passing the order contrary to section 75 subsection 4 of the GST Act.
Sir, may I read to you one question which is formulated by Supreme Court,
In a Tamil Nadu,
whether the High Court in exercise of its writ jurisdiction under Article 226 of the Constitution of India ought to entertain a challenge to the assessment order on the sole short question, the High Court sole ground that the statutory remedy of appeal against that order stood foreclosed by the law of limitation. That is the question posed by the Honorable Supreme Court and answered in the negative. High Court has no jurisdiction. Then what will you do?
Lordship,
that is
I'm grateful.
Glaxo.
Lordship, grateful Lordship. Lordship, I may be permitted to, Lordship, if the order I am challenging, if the submission is, since I could not file the appeals, therefore.
No, there are two distinct facets, sir. One is that a SSE has not filed an appeal beyond the period of limitation and challenges that order directly under Article 226. There is another facet where the SSE challenged the order before the appellate court along with an application for condonation of delay, authorities rejected the application for condonation of delay as the delay is beyond the outer limit set forth in the statute. And then he is challenging that particular order before this court. So there are two distinct features. One has already been answered in a GlaxoSmith matter. The Supreme Court has said negative. High Court cannot
Second,
and should not. Your case falls under second category.
Lordship, the
You approach the appellate authority. Application for condonation rejected.
Second category is more.
And if it is purely on principles of natural justice violation, it is the appellate authority who could have, instead of going there, you have sought for a remedy which is not apparent on the face of the.
Lordship, the commissioner is the whole case of the department, Lordship, and suppliers have not filed the
Now,
return.
that is on merit, we are not on merit.
Sir, here the problem is that the entry gate is closed. If the entry gate is open, then you can enter and say that this is what is the wrong.
Lordship,
But you are not allowed to enter now. The doors have not been opened.
Lordship, if I may submit, Lordship, the order in appeal was disclosed on the limitation, therefore doctrine of merger will not apply. Order original won't merge with order in appeal, therefore Lordship, I will permit to challenge the order original on its own. merits, Lordship. The very glass Smith case, second portion of it.
How you make a distinction? Is it not the dismissal of an appeal?
It is the dismissal of an appeal on the limitation. Lordship.
Maybe. So is it not tantamount to merger?
Lordship, as per the Honorable Supreme Court decision.
2000, I am concerned. 2000 volume 5 SC Kumaha judgment or
Punyam.
Kunyam judgment. I am conscious. But please also read another judgment of Shamsundar Sarma versus Pannalal Jaiswal. The direct question that arose was that the dismissal of a Section 5 application for condonation of an appeal is a simpliciter dismissal of the said application or will tantamount to dismissal of an appeal as well. If it is a dismissal of an appeal as well, then it's a merger. 136 concept as in that judgment is different, where the appeal has not been admitted. It's a special leave to appeal. Unless the leave is granted to appeal, it is not a regular appeal. So the Supreme Court has made a distinction. But it is a regular appeal, registered. Then
Lordship, one more issue, the demand is for the year 1819. They adjudicated the case after the time limit prescribed under the statute, Lordship.
As the appeal order has been challenged, so let him file appeal before the tribunal. It is appealable before the tribunal. So let him file, if in the meantime any amnesty scheme or tribunal, your lordship, because every day your lordship
Do
is
something, sir.
relegated in many matters. Your lordship only has committed a mistake by not challenging EL1, by not challenging the rectification order. Only that reason. For
the
that,
order has not been rectified.
not rectified, but your lordship 206 page 206, your lordship may kindly look into the APL1. There, the date of communication and order to be appealed against, one column is there, where we have to put the date of order and which order has been challenged, is to be challenged, your lordship. There he has put the original order of 2024, not the rectification order, your lordship. He could have filed the challenge the rectification.
That is an independent order, sir. So he is aggrieved by more.
Then your lordship, okay, it is beyond the statute.
Lordship, one more submission. My pleadings includes notification number 56 2023, Lordship. They adjudicated the case after the time limit prescribed under the statute, Lordship. By notification, they extended the time limits, Lordship.
Sir, I understand, sir. What is the purpose of promulgating the Limitation Act? by the Parliament. Limitation Act does not destroy the right. You may have a right, still your right subsists, but denies you the relief before the court. We are more on a relief which can be granted to you, not adjudicating your right. Your right may still exist, but you are not entitled to relief from the court. What more can be done?
Lordship, there are many petitions pending on the notification number 56, whether it is correct or not.
Maybe, sir, but you have missed the bus. If you miss the bus, it's very difficult to bring him back.
Lordship, upon submission, the order original is also independently challenged, Lordship. I understood, Lordship, Lordship, the GST Act is a new,
What is the new? So there will be a new concept, new law. The law which is there is one and the same.
Lordship, the original authority, without hearing the petitioner, passed the order.
That's a let us go to that extent, blatant violation of the principle of natural justice. But you can challenge that order, or these principles will be adjudicated in a properly valid instituted proceeding. If the proceeding itself is not permissible, then what? Can't be said to be validly instituted beyond the time, out of time. Take an instance of section 34 of the limitation, arbitration and conciliation act. Time limit for to challenge the award is already provided. Is it flexible? Outer limit? Series of judgments, Supreme Court has said you can't extend beyond that. Go for this Commercial Courts Act. Order 8 has been revamped. Period for filing a written statement is provided. Recent judgments have come and says that once the outer limit is provided in the statute beyond which the court cannot condone, court cannot condone. Similar position is here because the outer limit is provided. Beyond that, the authority, appellate authority cannot. If we cannot, then can we issue a mandamus to do a thing which is forbidden in law? Okay. That is what is the main issue. He has taken that plea.
Lordship, if that notification goes, my demand also will go, Lordship. Therefore, Lordship.
But if the outer cap goes, then you have a good case. If the law is amended in the meantime and gives an unbridled power to the appellate authority to condone, fair enough, good, no problem.
Lordship, the authority took a prolonged period for rectification now passing the order, Lordship.
Sir,
If they would have.
maybe, sir, this is why the period of limitation is provided, that at least the alert litigant must approach the authorities in a time-bound manner. And the one who slept in a slumber cannot wake and then come and say that you may have good case. But what to do, sir? What to do? Tell us, give. I just told you that if it can be it is permissible, it is permissible.
Right from Hongo, India,
Hongo,
excise and customs, NCLT, DRT, everything. Every statute now
Yes, Lord.
has outer cap.
Yes, Lord.
So consumer protection also.
Yes, Lord.
So that is also decided by Honorable Supreme Court.
Lordship, in all those decisions, Lordship, the appeal was filed after the time.
That is why my lord has said that there are two categories. One, directly challenging the assessment order for violation of natural justice or whatever reasons may be belated, whether 226 can apply. Number one. Second category is through once you have entered into the alternative remedial fora, then you have to exhaust that line. You cannot in the midst abandon and shift over. That is what I think my lord has posed this question.
But Lordship, various high courts, once the order in appeal is dismissed on limitation, so they honorable high court.
Have they taken note of the judgment of the Supreme Court in GlaxoSmithKline? None. We have
When was
been
that passed? When was that passed?
Order nothing, Lordship.
No,
original order.
the
Lordship, original order was passed on
30th April 2020.
24.
20?
Oh,
30th April 2024, Lordship. But the
So what to do?
Lordship, I am not complaining. The adjudicating authority also took longer period to take a action on that rectification application, Lordship. If they choose not to rectify it, if they communicated within the time, I can file the appeal within the time, Lordship.
Who is to be blamed?
I am not complaining, Lordship.
Well, I'm asking, who is to be blamed? If you chose to explore one remedy, then can you fall back and say that no? Immediately suppose on the last date of an appeal, you file a rectification application. What you are supposed to do? You have to take time. They were to give you, again you will come violation of principle of natural justice.
In this case,
I'm saying, if rectification is dismissed on that date itself, again you will say violation of natural justice.
Another facet also I was examining whether the appellate order was passed within 1 year period, which is stipulated in the statute from the date of filing of appeal. That is also emanating from page 270. Your appeal was filed on 21st February and the order was passed in September. That is also, that line also we are not.
Within a year. Tell us. Nothing. Then what remains? Then what remains? Yes.
Lordship, my petition can be attached to the batch where the notification number 56 is on the charges. I have taken that ground.
Sir, you are taking a circuitous route to get away this point. The moment we tag it, that means this point will not be available, and on notification, the argument would be advanced. That means we have entertained the writ petition and ignore this particular aspect. What you cannot achieve directly, you will not be permitted to achieve indirectly. So, very difficult bench for that. Very difficult bench. We will not permit you to take a circuitous route. Answer that first question on the maintainability, entertainability. That's all. Thereafter, we'll enter into the merit.
They kindly give me 2 weeks time, Lordship. I will do further research to Lordship. I fall under the first facet, Lordship, where since I traveled to the art and original also, HON'BLE India and GlaxoSmithKline are all not coming in my way, Lordship, because I challenged the art and original also, Lordship, on the ground of violation of principles of natural justice, Lordship. And another point, Lordship, the supplier has not paid the tax. That cannot punish the recipients. That is the main issue, Lordship. And that is the.
We have also decided that point already.
But Lordship, here supplier has paid the tax, Lordship, they are not considering that.
To accept to his submissions. He has made a rightful concession, it seems to us. You should have taken the advantage of his concession immediately.
Rectification order. Rectification order. Ample opportunity to do it.
Lordship, then, Lordship. Then,
Should he repeat again?
Lordship,
You have a remedy, exhaust that. It is better.
Lordship, then,
We don't know what proposition tomorrow he may come out.
Lordship, that is the reason. Lordship, kindly grant this stay, subject to payment of 10%. Once tribunal is notified, I will go and file the appeal.
It has already been notified, sir.
It is.
The circular has already been issued by the authorities. Period has been assigned. Time is given. Within that time, for this period, you can prefer an appeal. So I do not know whether your time has elapsed or your time has not elapsed.
Copy of the order, let him peruse, come back. No, come back means after passport.
That is the order.
When the time is allotted to him for this appeal? Which period? This is for which period?
18, 19.
He can file immediately because the Honorable President has withdrawn that staggering notification has been withdrawn by Honorable President.
Who?
So now, at any time, anybody can file the appeal.
Then this order will not. You should have.
Just now.
Please give us that.
That notification I am giving.
So it says that any time he can file.
Your Lordship, that period, staggering period has been.
But
Till
so
June.
far as a limitation or till June, that is what.
2026. That is the last year also.
Oh, then it's all right.
Staggering notification.
Go file.
Also,
Yeah,
give us that
I'm
notification so that.
I'm
we
just
can-
giving.
And there you deposit 10%, happy. No coercive steps the moment you deposit. And let us see what emerged from. There is already one matter is under the active consideration.
There are diverted to use among the reports on the class.
Sir, can a High Court take a dissenting view to the Supreme Court judgment? Had they noticed the Glaxokill and they do not apply any other judgment of a coordinate bench rendered earlier or a larger quorum or a subsequent larger quorum judgment, then in that event, they are bound by the judge. Yes. We are passing that order permitting him to
Your Lordship.
exhaust a remedy, give that notification and go deposit, no difficulty.
Published lot.
Yes, next.
Item number 12,
The
both the cases.
one,
Second one is against also first appeal.
Same,
Both.
Yes, the first appeal has been disposed of on merit, Your Lordship.
on merit.
Your Lordship.
in this case also order original was passed without hearing the petitioner. I took that argument.
Go before the tribunal, you are within time. So there is no difficulty, your matter would be decided on merit.
After the original order was passed without hearing the petitioner, I took that objection before the First Appellate Authority. First Appellate Authority not considered that objection, Lordship. This case Lordship can be.
He is within the period of limitation now. Period of limitation is June.
Yes, Lordship.
First appeal.
Second matter, if it is a violation of principle of natural justice, then why not?
First appeal order has been challenged.
Oh,
First
oh,
appeal order.
true.
So tribunal,
Why tribunal? That's the alternative remedy is not an absolute bar.
Your
He is within the period of limitation. He has an alternative remedy to go to the tribunal
Lordship,
till June.
Your
He
Lordship,
has come in the January.
Your Lordship.
If we find there is a violation of the principle of natural justice, will we not exercise that power?
And come to the first appeal order. That has been reasonably passed, Your Lordship, after considering all the.
First order,
Original order, Your Lordship, original.
it is devoid of the principle of natural justice.
Original order, Your Lordship, detail.
So why he will lose one forum?
Your Lordship.
Once the appellate authority has taken up the responsibility like an assessing officer and then decides the matter on all count, then he is losing one forum.
Your Lordship.
He's losing one forum.
Let me place two paragraphs of the original order. Your
Yes.
Lordship, how the opportunities have been granted, Your Lordship.
Yes.
Your Lordship, page 79. And
Yes.
whereas you have been intimated this discrepancy, inform GST SMAT 10 by reference number so dated 24th May 2021 as per section 61. Rule 99, read with the direction of the discrepancy so. You have furnished your explanation. Inform GST SMAT 11 dated 16/8/2021, where you have submitted your reconciliation statement for the year 1920. In the said document, you have stated as follows, the table. But on scrutiny, it is found that you have claimed excess ITC of rupees so and so under IGST in the year 2018-19. You have failed to produce any supporting document to establish your claim. Hence, the reply submitted in is not found satisfactory. Again, a so-called notice under section 73 in DRC 01 issued to electronically by reference number so and so, undated so and so, to pay the tax along with the up-to-date interest penalty. Furnish a reply along with supporting document as evidence in support of the particular claim by dated so and so. But neither you have appeared nor furnished any explanation with stipulated period of time. You have also not made any payment, tax, interest, penalty, and hence adjudication proceeding so and so. So you let's see.
No. In the appeal, has he taken a plea that he has submitted the reply or the notice was not served? Or show cause, that's on the basis of show cause under section 73.
Yes,
Oh, initially you wanted a clarification showing the discrepancy and then you did not find a satisfactory answer.
Let me place the paragraph in the first appeal.
Yes.
119 you let's see.
Yes.
It is evident from the appeal record that the dealer petitioner has filed appeal so and so and dated so and so along with the annexure. After receipt of application, the hard copy appeal to one. The appellate authority issued notice for personal hearing on dated 18/8 June 2023, fixing the date on dated so and so. Finally, on dated 7/11/2020.
Taken that.
Demand. The
Please,
petitioner
please,
appeared.
please. Mr. Counsel, come to page 118 of the appellate order. There, yes, no, taken the plea of
Natural justice. That is a different.
Ground has not been grounds of appeal. These are the grounds of appeal you have raised before the appellate authority. Page 118 of your.
There are Lordship.
Sir, page 118 of your
No.
petition.
He may say that the appellate authority has not recorded the full ground.
Grounds of appeal.
My grounds of appeal, Lordship.
He has quoted here,
At page 89, Lordship.
sir.
At page 89, the ground started at
Page
page number
89.
99. Page number 98 and 99 specifically on my natural justice violation, Lordship. 25 for
Page?
98 and 99, Lordship. 98 last paragraph, Lordship. this issue, my humble submission not addressed.
No. A show cause notice was given to you. You neither gave a reply nor you did anything. Then what do you think the authorities are supposed to do? What do you think? Because it says opportunity of hearing shall be granted where the request is received in writing. If you do not appear, then where is the question of request in writing comes?
May read 75 Lordship.
Sir, I read that, sir. You have quoted. The first line says, an opportunity of hearing shall be granted where a request is received in writing from a person chargeable with tax. So you have to show this, they will follow only when you have requested in writing for a personal hearing. He says a show cause notice was issued, that was served. You did not file any reply. You did not do anything. That shows that once you did not appear, file your reply to a show cause, then there cannot be any request in writing for hearing.
Lordship, the second limb I will permitted to read.
Yes.
The first limb is separated by comma and R.
What?
Where any adverse decision is contemplated against such person.
Hmm.
Lordship, this is independent, both are mutually exclusive, Lordship.
That is why already given opportunity to appear and explain. You did not participate.
First, adjudicating
You
authority,
chose not to participate,
adjudicating authority has not given any hearings or opportunities, Lordship. May I request Lordship to see,
which
to come to show.
Mr. Misra has read to us that portion. It seems intimations were given to you.
Lordship, may I request Lordship to kindly see page 67, where the opportunity for hearings has been given as a blank, Lordship. The order and original also nowhere mentioned that on which date they have given a hearing, no details about the hearing, Lordship.
67.
Page number 67, Lordship.
Within the first place, secretary being extended from a person.
67 what?
Yeah, you are also
In the table.
on fact, it-
Sorry,
Thereafter,
then he will be losing a forum.
Yes, Lordship.
Had he raised all those objections
Yeah.
on factual aspect, and the assessing officer decided against it, then he has a right to go to the appellate forum.
both the proceeding,
But if the appellate forum exercises the power of the original forum,
yeah,
then he is losing.
both the forum opportunities have been granted. That in being your
It has to be read in a more pragmatic manner. Once you did not appear, it does not mean that the authorities would stay their hands eternally or perpetually because he is going to pass an adverse order.
Lordship, at page number.
Sorry,
Lordship,
this cannot be a proposition. You did not appear.
Lordship, they have not granted the hearing opportunity, Lordship.
What are you talking? Where is the denial?
Lordship, at page number 67, Lordship.
Where is the denial that you applied for hearing and he refused? Show us.
yes,
Second, the portion of the notified
before the appellate authority.
No, 67, what it says.
That no, not
No.
only the personal hearing, column personal hearing, you see,
Uh,
against that NA is written.
Not
So,
applicable.
not applicable, but subsequently he has given intimation.
No, Lordship, that is what my.
Mr. Subsequently you have not given.
My learned friend, the talking.
This is the original notification initiating the proceeding, asking you to file written reply. Thereafter, he has given intimation on clarification.
Lordship, the advocate submitted the hearing opportunity before first appellate authority. Not the adjudicating authority, Lordship.
only after replying when he is calling for the personal hearing, you know, so
What?
let's say, this-
How can you deny even an appellate forum, deny the personal hearing?
Oh, appellate forum, personal hearing is there. Not that enough.
He's saying even before the appellate forum,
Appellate forum has given opportunity, but impeaching authority has not given.
original authority, show us that you applied for personal hearing. Where is your application? Show us.
Lordship,
You did not appear, you did not do anything. What he is supposed to do?
Lordship,
Sorry.
Lordship, second portion of section 75 subsection 4.
Sir, that has to be read in a more pragmatic manner. A person who neither files a reply after receiving the service, the so-called notice, nor appeared, and then authorities definitely are contemplating to pass an adverse order. If you do not appear, is the authority bound to remain stubborn for all time to come? He will go on inviting you, giving you an invitation card, come, and will never decide you will never come. An unscrupulous litigant will misuse this particular provision of law for all time to come. Even there will be a better advice from there not to appear, so that never adjudication can be made. Even in the lifetime also, they cannot make an adjudication. That is what you wanted to contemplate. Is this the spirit of this section? Take an example. An unscrupulous litigant is receiving a notice but not going. You say adverse, no request in writing is required. It is a bounden duty of the authority to give me personal hearing. I will not go. I will never go to the authority. Will he remain stubborn all time to come?
Actually, once the notice is issued, that is subsequent compliance, sir.
Sir, nothing, sir. The notice has already been show cause was issued to you. Reply was sought for. You did not. Then what the authority will do? Cannot sit idle for all time to come. There is also a period which is running within which they have to complete that entire adjudications. So this cannot be interpreted in such a way which would frustrate the very purpose. No, sir.
Sir, if you come
We
to
don't
page
accept.
80, page 80, 80.
Unnecessary. Let us go to tribunal. Unnecessary.
So after initiation of such an investigation proceeding, to initiate the proceeding under section 73, they have issued you the notice, which you have enclosed. Again, a show cause notice under section 73 in form so and so was issued to you electronically. You are not disputing this.
Yes.
To pay the tax along with so and so, and or to furnish a reply along with supporting documents. Have you complied with?
No, he has not.
Not.
Never.
So, had you complied with this, then you would have a case that they have, while passing adverse order, or while discarding this, or while disputing this, your explanation, if they are passing any adverse orders, at that stage they have not complied with natural justice, we would have accepted. But since you have not taken any steps against the original notice itself.
Go for appeal. Tribunal.
After
No.
last submission, Lordship. After the order in appeal, application for interpretation was filed, Lordship, because the order in appeal says, since you have not filled so and so tables, sir, we are denying your explanation, sir. But the tables are optional, Lordship, as per the government notification. See, I filed the ROM application, Lordship.
Go before the tribunal and take all this, please. Yes. You're not. Saying alternative remedies.
Yes, sir.
We are not.
Submit.
We are not inclined to exercise our discussion.
Let's submit WCC number 583 of 2026.
Yes.
Alternative remedy. Sathical.
Fiscal.
It is always great learning experience to appear in Nazi before.
Item 12.
Please, my lordships. Lords, I'm praying for a week's time. There are some inadvertent errors in the memo of the petition, which needs to be corrected, my lords. Only a week's time, my lord.
That is to be done.
Adjourn.
The prayer become improprious.
Item 13.
That this matter gets some calculation.
Item 14.
Let's not similar.
Yes.
Item 15.
Yes.
Item 16.
Yes,
Yes.
Item 17.
Multiple assessment with a single proposal.
Yes.
Item number 18.
The license of Outstill Liquor Shop. He filed an application. Outstill Liquor Shop. Manufacture.
Outstanding or outstation?
Please. Outstill. OUTSTIL. Outstill.
Oh,
Still,
So
what is this?
that
Manufacturer.
application process.
Okay.
He was granted a license. He couldn't find any site due to public objection. He filed an application for surrender of a license. Without considering that Superintendent Excise has issued the demand notice under Annexure 15. And he has issued also SOCOS notice. I submitted reply. Only one line is there. The SOCOS reply is not satisfied. No reason. And for surrender, there are two requirements. 1 month notice and you will deposit entire license fee. I paid entire license fee for the about 1 year, 6 months. That is license fee is about 3 lakhs. About 18 months I have paid. And they have now saying that you pay the utilization fee on MGQ. I have not operated on a single day.
Yes, how can you? What MGQ? Why? But why MGQ? Because you are the manufacturer.
Yes. I have also MGQ.
Then what? MGQ?
Yes.
What?
I have not operated.
MGQ for what?
Minimum guaranteed quantity on Mohawk flour.
Oh, flour you have to purchase.
Yes, Lord. That
Minimum.
license also they have not granted.
If there is no cultivation of a mahua flower,
But that can purchase from the outsider. There are licensee who are selling also Mohawk flour. I am purchasing also there. If the not get outside,
I understood. Yes.
1 week for instructions, my lord, because the concerned officer had just joined, my lord. So I could not take instructions in this matter, my lord.
When he joined?
50, I think 1st of
This
this
month.
January, my lord. 1st of this month, my lord.
and consequent blood also they have already passed an office order declaring a defaulter, non-payment of demand.
This card.
It's 1 week for the take instructions, my lord.
1 week for instruction. Next week.
Item number 19.
Lifting of 180
Madam, what are you doing? Where? I believe Mr. Advocate General is here.
I have spoken to the department. They are actually thinking of changing what steps can be done to.
Another policy is
Yes, my lord. Yes,
in the offing.
yes, ma'am. That's right.
So why don't you take a decision? I do not find any rational in it.
Politics, my lord, no, my lord.
State is not loser both the end.
Yes.
That is what I'm saying.
You are also not. You are also not.
Huh?
Because 180 is allowed by.
State is losing.
Say.
State is not losing both things, and you are also not.
It's a 100 ml size liquor, they are allowed in also. Previously, it was allowed. Now thereafter they have stopped it. Now when they stopped it, the on-shop people are challenging it. Now allowing 180 in shop, state is gainer. So that is why they are not.
No, state is gainer in all the senses because the excise is levied on that, which is either a 90 ml or a 60 ml or a 400 ml or a 500 ml or a 1 liter, 2 liter, 5 liter, everywhere on the quantity. Barrel. My brother has correctly said, even a barrel. What is this?
There is a limit also. If it is barrel allowed, that will be.
Maybe this is the issue of refund. For two assessment years, the lordships have passed an order. The department was supposed to seek instructions with respect to.
Lordship, we need some more time to file an affidavit. In sake of affidavit, we have been instructed to file. And it's a short date, may I need to file it. That already we have passed the order, your lordship.
That has not been given to us. If
I have already put one instructions. Assessment 2009 is
Yes, if
there.
you know the appellate order,
Manage.
if you know what the appellate order, we have expected the appellate order.
We have already issued my refund and credited to us account. And the factory report I have got it from department. We will file the affidavit, new one.
In the meanwhile, I have received this, right? I will also take.
You have decided to refund 1,90,999.
Your lordship, 9-10, we have issued 3 times refunds. Annexure.
That is till 2022. This figure is of 2022. Applicable interest will be 2025 as to
So you have already, why you have not refunded this money to him?
No, already refunded, my lord.
No, decided to refund, determine refund amount to rupees such and such. Then have you refunded that amount?
Yes, madam, that's refund.
There is some refund that has been granted 6 months prior. But however, that is a lump sum amount which has come in the company's account. However, there is no distribution. Our case is that there is a refund of, there was another batch of matter which consisted of 5 different assessment years. So we are not aware under what head of which year how much refund has been granted and interest calculated up to what. Because this giving effect order is of 2022. If they have issued refund based on this 22 order, then interest from 22 to 25 has not been given. So we need a consolidated chart which my learned senior submitted, that he'll be giving a consolidated chart where we'll know assessment year wise how much refund has been given in pursuant to the giving effect order. That we don't have. So we are not able to ascertain whether the amount which has been credited.
Give a details.
Of all the 5 years, the lordships have already disposed that matters of 5 years of this particular SSC.
Well, this present petition for 2009, 10, 10, 11.
Where is that order? I think,
I think the assessment year, annexure 6.
certain times they have adjusted, we have said
Yes.
no adjustment is permissible.
You
Yes.
come, they have talked about 2010-11,
Yes.
annexure 5.
When
You
appeal
come,
was, when
This is for
appeal was pending-
2012-13.
No, when this appeal was pending, they have sought to adjust that entire amount, appropriating towards
In this SSC's case,
discharge of another. No, you cannot.
and in this SSC's case, there was 2 issues. One with respect to the refund.
I think
Another
another is for refund.
Yes, another was with respect to 15% deposit while filing the appeal. So that figure is also there. So it is, we have given representations also that you tell us that this is the amount we were supposed to get. This is the interest as per this section, how much you have refunded and how much you are supposed to refund as on date. But that is very, yes, that we can verify that. But has to give a consolidated chart for all the 5 years.
No, they have given 2009-10, 2012-13, 2010-11. These 3 years.
Yes, your lordships will see, these are the orders of giving effect order and the figures is of, if your lordships will see at the top, at annexure 6, that the date of order is of 19 to 2019. So this figure which they have arrived at is of 2019. The assessment is of 2010-11.
Correct.
So the refund which has been given to my client is, I think, in the month of June or July of 2025. I'm not ascertained what is the date, but it has been
They have
taken.
not changed that chart.
Yes, that is what the updated calculation sheet has to be given, because
Up to date, correct position. you are
yes,
not-
if this figure of 21,20,000 is till 19 February 2019, then what about the interest from 19 to 25?
Yes.
Recently, we have passed one order
In
this.
9-10,
I
we have already issued the refund with interest, annexure 4 can be verified. Your lordship, that total amount of refund comes to 23 lakh some odd.
Sir, the position, correct?
Position. I'm telling you. 9-10 already refund has been issued with interest in 2022 itself. And for 10-11, refund has been issued of 21 lakh 20,000 some odd. We have to verify whether interest has been paid or not.
That is undisputed, your lordship. That we are not
That is
disputing. We are disputing the final amount which they have arrived. Have they disbursed that amount with interest as on date or not?
No.
That refund we have already submitted in our rate petition, that it is there with us. That we are not disputing.
9-10 already completed, your lordship. Assessment year.
Unless and until we know, your lordship.
So when you make the payment, when you make
In
the
shape of
payment,
affidavit, you file the lordship.
there is no date which is given when you have. You may have passed an order on 21st of February 2022 for 910. But this amount, whether it has been paid with interest as on the date of the disbursement
Yes.
or not paid with interest.
Also on the principal amount, in my rate petition I have disclosed there is certain amount, a meager amount, but certain amount which is not.
And what
been
about the
credited also.
deposit which they meet as a statutory deposit?
Yes, this is
That
that
has-
rate petition, your lordship. That 15% deposit which we deposited at the time of.
That
tax
has to be
appeal.
refunded. Why you will not refund it?
Yeah.
Verifying on file one affidavit.
That consolidated chart, unless and until it is given for the entire SSC for all the 5 years, it is not possible to match the figures. This
You
2
will-
years cannot be
you will
hand
file an affidavit by 1 week. Yeah. 1 week. Both the matters.
both the matters.
Item number 27.
The question which was submitted before the authority in due time, it has not been disposed of till this. No information has been
Your
made.
lordship, last time of the last occasion, it has been given an instruction that regarding this refund, the refund was rejected, your lordship, on the ground of non-compliance. But we are accepting there is amount is lying in IGST. The amount they have paid extra amount in IGST. But direction may be given so that we can flow that. If a direction may be given from this honorable court, that IGST refund will flow.
Dispose of. Yes.
Item 28.
Lordship, item 28, I have received the consolidated copy of the petition yesterday. 3 weeks time may be granted for filing of counter.
Counter. It is submitted by Mr. Mishra that he has received the copy of the
Number 29.
29 are single loaded for multiple assessment.
let us dispose of. Is the hearing matter. Argue
In this,
29.
single notice for multiple years, assessment years. Argue, we decide the finally.
this
Why will keep it?
next we will.
Again, one of the High Courts have already,
In also.
so.
I
we'll
think,
follow
I
the-
think, I think Madras. I believe Madras.
Which court? Which High Court?
Huh?
The Delhi High Court one, Delhi High Court.
Supreme Court.
So what do you mean?
Confirm this,
SLP dismissed.
That is so far the ITC is concerned. No, that is not. That is not.
No, no, it is the case of a multiple assessment years
Another-
covering under the one notice.
There is a fraud ITC. Overlapping.
That is not.
That is a different. We are concerned with the multiple assessment year in one notice. I think Madras.
Madras High Court.
Yes, I believe there is a Madras High Court.
That is Bangalore.
very much.
That is
Remax. So why keep this matter?
Next.
What next week? Decide all these matters. There are, I think, hundreds of matters are.
Kerala Division Bench is there.
Give a compilation of judgments. Make a compilation so that
We'll decide. We'll.
why should we take a different view from other?
No, Bombay High Court is also.
Because this is pan India, this CGST also applicable. CGST and state GST. So.
When you can give?
Next Thursday.
So I think we have got all of it.
Yes.
2 weeks time.
Bring up because in one of the cases we will decide it will.
It will cover the hundreds of.
all cases.
Next week, you give within a week. Give within a week.
Yes, ma'am.
Next week, okay.
Raju fixes it to 2 p.m. And then
That day, next Thursday, I think that mining matter, next Thursday, mining matter.
এটা কোন চিকে সিএ দেবে সে কম্পাইলেশন দেবে গোটে কেসে আমরা ডিসাইড করবে আর কোন আর্গুমেন্ট করবি
No. How are we? In fact, personal state GST, till date, state GST has not passed any order. It was on multiple years.
then TANDON will come up with to distinguish.
Keep it in the next week. We are not doing anything. Keep it in the week. Next week, you give a compilation on that day.
Item number 30.
last particular 15 January.
Thereby the mistake in DRC issuing of DRC 07, in which instead of interest, it has been column in a IGST account. So while going to second appeal, they have to deposit 10%, unless until that appeal won't be admitted. And Lordship, direction may be given to the department.
I have one.
They'll put.
We have said apparently mistake has crept up.
So we have already informed to the department.
Paragraph 1.1. Read.
I've already informed to the department.
Well, we can't get it done.
It will take some more time because the file has been transferred from Cuttack to Bhubaneswar jurisdiction.
Why are you asking us to?
If this matter may be disposed of now, so I'm saying that way. Then they'll file an appeal.
You are inviting some problem.
Then I'll be taking instruction and I'll be this.
1.1 is very clear. We have said that is apparent the mistake has come. You have to do it suo moto. Why you are not doing it as suo moto? That's a mandate.
Lordship, I have already informed this matter has been transferred from Cuttack to Bhubaneswar file. So a segregation of that one jurisdiction issue is coming. So they take more. I'll take another 1 week. I'll be disposing.
Next week.
And appraise this order.
I've already informed.
To the proper officers. So that
Through mail, I have already informed to the department also.
Item 31.
The 57 for lots of plots is a regulated market committee plots constituted on the Odisha Agricultural Market Produce Act plot, that is 75 plots. It's a local authority. The powers are vested as a local authority and they are exempted on the income tax. All incomes are exempted below. Earlier provision of 1020 and subsequently a virtue of 2009 amendment laws under 1026 AAB.
So instead of association of persons, you wanted it to be a local authority.
Exactly. I have framed change of status. And that prayer was made pursuant to a communication by the Agricultural Market Board belongs to all the constituent of regulated market committee across the state belongs. Restricting that wherever these have led to compliance issues belongs because unless those are absolutely corrected, because now by virtue of 2009 amendment, what is exempt from the Income Tax Act of 1026 AAB is regulate agricultural produce market committee. So therefore, unless appropriate finances belongs reflected in the PAN, so the compliance issues and the exemption, all these are there. Therefore, board which controls, regulates the affairs of the committee belongs, made a communication by the annexure belongs to all the committee, including myself, to this committee also. Belongs to page 16, my lords will find page 16. And my part is way back in 1972 millions with status of AOP. So then came Agricultural Market Committee communication with annexure to page 16, my lords will kindly. We request that each RMC immediately review the type of registration mentioned in the PAN application process. If the registration type is found to be incorrect or not aligned to local authority or government agency, please take necessary action to amend the details accordingly. Correct registration type is essential for ensuring compliance with tax regulation, avoiding any potential issues with the internal department. So we have for this I made an application to ITO belongs, right? Annexure 3 and next annexure 4, ITO said no, you can't make physical applications. You have to apply online. So then I made an application online by annexure 5 bills. You will also find the acknowledgement after making the application online bills. That is
page 19.
Yes. The token number was raised after I made this online application. This is acknowledged. Actually, you also will find. Then there is a bottom of the page. You will download PDF. In the download PDF,
download PDF.
So lot of will find what was there download PDF. The next page, page 20. That is what I got after filing this application. This download PDF is a request for, it's a format, request for new PAN card and changes or correction of permanent account number. So what I wanted should have been corrected by way of this formatted application. But unfortunately, the formatted field which is available here, the download PDF, change of status, all they are there. We have change of address, all is there. But change of status is not there here. What I found. You will also kindly see column.
No, why not the correction in the permanent account number?
Yes.
That includes the status from an AOP to those. So it comes within that.
Correct. But it should be there in the field, appropriate field to fill it up so that can
since there is no field to fill up.
Exactly,
to show
any other omnibus column?
No. Would not have it. That's the problem. Because then what happened, you will find from the next annexure 7, I got a communication after from the e-portal communication. But again, portal communication. Page 22, you also kindly see for page 22
is not valid.
Yes. Your request for changes or correction of PAN date for PAN allotted to application status not valid. We have received documents so and so. The documents are not valid. And what the reason means? 3 reasons are there. You also will see down 1, 2, 3. And the first reason is PAN card will be dispatched only to the communication address provided in your PAN application. Wherever the representative assessee RA details item number 4 of form 49A are mentioned in the application. PAN card will dispatch.
No, this is not. There is a column. Click here.
Yes.
I think you have to go and click. That will give you a exact. This is not. This is a very omnibus direction which has been given, incorporated in that particular, the column itself, the page itself.
Correct.
So this is what is a click here. But after that,
what pop-up from the portal mirrors is this?
No. After clicking, what will appear?
No. That's the status. You see, your request for changes to taxi, last box.
Last yes.
Status against the taxi, we have received the documents with reference to your PAN application.
Correct.
However, the documents are not valid.
Yes.
Full stop. Tap on it.
Please click here.
Click.
I clicked. And
Then-
what pop-up is 1, 2, 3 down.
No,
Yes.
it is if it is one document, then the entire document will come. That's the omnibus direction. Click means give you some different. You have not clicked.
It's not there. It was only one table.
Oh.
So we clicked there.
Oh,
The
that
second
came
table came and we have taken the screenshot after that, Your Lordship.
Acha, screenshot take.
Yes, Your Lordship. If we would have taken the screenshot before clicking, then Your Lordship could have seen that there are two
This
instances.
line.
Yes, Your Lordship.
There
That is why there is a
This
section.
line. Box.
Yes, Your
And
Lordship.
this is the box, one line.
Yes.
And what 49 says, the next page, Your Lordship, the 49A says, it's a application for new PAN application.
Then this is not
No, it's not applicable.
No.
And
You want
Lord,
amendment. You want amendment of
Yes.
status.
Correct,
Change of state.
absolutely correct. And you've been authorized on the provisions of 139A minutes, which is the provision minutes. No, if an access is granted with alpha numerical number, here alpha numerical number was there, just long prevalent. Unlike the very previous system, then no fresh PAN can be granted. So therefore, the PAN application and grant of PAN also cannot be, new PAN cannot be granted to me. So unless, and there is no provision otherwise on the statute also take care of my demands. Unless you are not sick, that's something rescue will be sir.
It is subject to verification, madam.
What subject to verification? There is no difficulty that he is a market committee. He has already applied a PAN. You have issued a PAN as association of persons. He says that he is a local authority. So you'll have to just give a status from AOP to local authority. Where he will go? He made an application in physical form. There is nothing, I think the block or the space for this purposes. Then what he will do? What he will do? Take an example like this. Is a private limited company.
Right.
Granted a PAN card. He applied before the registrar of companies and converted himself into a public limited company. Same thing. Entire assets, everything, liabilities, everything vested into the. What he will do?
In under VAT also there was provision. Under it form. Final form, then.
What he will do? Just tell me, give me.
The document submitted by the assessee.
What he will submit? He has submitted the circulars and everything has come. You have granted it to somebody else, but you are not granting him. If he applies afresh, I am telling you, if he applies afresh, then you will grant him as a local authority.
He cannot grant because of restriction under 139A5.
No. For the first time, if he is a first applicant, I'm talking in that sense. If he is a first applicant, similar nature, will you not grant him as a local authority? So the person who has already been granted as AOP at one wanted to convert, now he has become a local authority or he is a local authority. Will you not change the status?
What is your explanation to page 20? पर अगर देखना देखिए जाने ना तो कौन सा explanation
The association asked the queries to satisfy that the PAN card will be discharged only the communication address provided in your PAN application.
कौन explanation देवे केमिति करिवे त
No, like to. Because already The ITO has already requested the associate to file the online application. And
Sir, online applications, yes, he says I am ready to give it, provided the online application contains a particular information to be furnished for this purposes. He says this online application does not have this. And once he is putting it, you are treating online application in a very conservative way. That where he will go? Either you have to refresh your entire system. There may be an omnibus column where any other which does not come, if you want, he will specify what he wanted.
That will happen.
One column should be placed.
and approval directions were given for changing the status.
It is really a stalemate situation.
Computer direction the way to administrator.
Now, it appears from you that the court will take a responsibility of running the entire income tax department or a GST department, what they should do, what they should not do, all administrative decision you wanted through a judicial. But it is you, he has flagged an issue, discrepancy is apparent. It is not that discrepancy is not there. Some mechanism, some decision has to be taken by you. I think CBDT is there. What for? They issue instructions. Are they not? In income tax, are they not issuing instructions? So,
opposite part number 4, I have added tax information network, TIN. They are managing this portal.
He is representing, sir.
Yes, absolutely. Correct.
That's what we are asking him. What is the explanation of the department? Through him only he has to.
They have the responsibility.
on the last occasion, it is because of you we adjourn, you take instruction. How many, I do not know, instructions are, that means taken in a very conservative manner, only one thing which the court observed. Next day, the court observes something else, then again instruction. Third day, on the basis of that instruction, some more queries are raised, then and again instruction. I believe the officer should be present in person so that if we have any queries, he is there to understand. So we are directing the officer to remain in present. Yes. Agreeing, you are agreeing.
We have seen now, by now, two cases. This one, on the earlier occasion, it stood adjourned, of course. But you have seen the plea. You should have taken instruction. This is one, the other one is GST. You will come in, go on putting the figures in wrong columns and you ask us to invoke our jurisdiction. Then with some actions, that also you have to take. Adverse actions against officer concern, that would meet the justice. For all trivial matters, if people will come to High Court level, taking the use of AI and auto population.
So these technologies, these are used just to enhance the efficiency in the working of the department, but not as an obstacle or the hurdle it appears that it is being used as a hurdle, clogging the entire system. Then what will do?
Can't just keep mum, sir. You have to have some explanation, sir. In each case, just keeping mum and you are not explaining.
No, when it is technical issue, minor. Is it
I was
technical
going
issue?
to say in a different language.
Or department.
Of course.
The same thing.
This purely technical.
No, I appreciate.
It's not for us,
Correct.
not for you.
Not for me, that's correct.
The standing council is there, senior standing council is there. Just to activate his own office. He will not assert his own jurisdiction, then who will?
Don't you have the support staff in your office? How many? How many?
Three.
Why don't you activate them all the time? To go and contact, to see, seek for. That shows that you have.
3 occasions I had to write a big judgment. That was unwarranted for you, for your officer, not me. Still they are not. So we have to call it online. They are not insisting for appearance in person. Online, at whatever time they choose, we will activate our system. Even if we are using AI mode, but still we are depending on our.
Next week, tell your officers to join on virtual. Yes, next week.
And if possible, do it. Mr. Kadian, you should get here. Then assistant.
Item number 32.
Ask for them. The wrong varnish data they have demanded. Under the RTI Act, even there is no wrong executive involved. Varnish data.
The executive engineer has uploaded the data
Wrongly.
wrongly
In
against
some-
his name. So
There are
accordingly,
two
we have,
person in same name. In other plan, in my.
accordingly, we have
So under
completed
the RTI
the,
Act, they have given there is no, I have done, but now they have got the instruction also.
accordingly, we have completed the assessment.
And I did not appeal also.
And subsequently, he has applied under RTI that after his RTI application that has been rectified that the executive engineer and they have given the information, based on the information he has filed the read. We have called for the instruction from that executive engineer and that executive engineer has given the instruction in the second page. Your lordship, whatever in the RTI that is wrong. So hence your lordship may allow.
Page 46 is the RTI.
Once they have uploaded, it has been uploaded in our portal, so we have completed the assessment. Only in 2025, after disposal of appeal, he has called for the appeal, sought for appeal.
No, but
Again, the same problem. Your authority has access to other departments.
I have already told. I have already told them, third party that.
Intra authorities.
No, of everywhere, because in 26 years they have rectified later on. After our action, they have rectified. So it is the fault of the executive engineer, not the.
But the appellate authority has not considered the 26 days. In 26 days, there is no zero.
No me.
Not a single communication.
63 का मैं करूँ we are sending 63 because on register after your lordship's interference all 63 unregistered dealer, we are trying to send the, not only uploading in the portal, we are trying to solve it physically. Because they are not in a position to look into the portal.
But affiliates are feeling that 26 is irrelevant. 26 before that is zero. Transaction is 26.
Portal, we have faith on our portal.
26 is more.
All the three petitions.
And last one, my lord, they have uploaded some other, it is not in my name. Some other order has been uploaded.
I have already considered.
So here, my lord, they have to give some, because I am not doing any business. Then a chance nahi. Sir, किसी तरह income नहीं लॉकेट में खर्चा कर चला है.
Your lordship admittedly many mistakes are there, and we are trying to rectify. Your lordship, many mistakes I admit. I have also.
But some legal cost and pre-deposit has been put in one pocket.
Copy pasted order. Your lordship will see. Your lordship. Yesterday night I have.
Their latches is suffering from last years.
Copy pasted. Even Shokas has been copy pasted in order. The same. Last line is the same, your lordship. We are trying our level best, your lordship, to advise all the answers.
I am made a judicial also party in this case.
All three cases.
3 years.
Lordship, item number 33. I have
33.
obtained the instruction. Lordship, a small counter is required. Your lordship, 2 weeks time may be granted for 9 weeks.
Issue is very. But my life is same. Only you.
Belated application. It is my lord to decide. I admit belated application you have filed. It is not disputed, but some factual disputes are there. In the instruction, thorough, clear instruction is not there. For that reason, I say
We have got it.
Item number 34.
After lunch, you pass out.
Why?
I learned English and more than common. One person.
Item 35.
Yeah.
My lord. This is a matter of pertaining to SVLDRS. Sabka Vishwas Legacy Dispute Resolution Scheme 2019. And this scheme has come by a parliamentary legislation interpreting chapter B in the Finance Act, that is that law, containing 15 sections, section 122 and 33. Perhaps broadly, this scheme, which I said, precisely contains 2 elements. One is the resolution or the amnesty. That is the start of the government of India is their own surplus thing. But before I point out your arching plans, here what has happened? Perhaps so far as scheme is concerned, it provides that when there is a demand, either arising from out of quantified demand, arising out of any so-called or any because investigation proceeding, some or such, if it is quantified, then if the assessee intends to have the benefit of, and the whole idea behind is, that is what the government of India amnesty provides, that to reduce the legacy baggage and to put an end to the various litigations with the advent of this GST, because 21 different indirect taxes, they are subsumed. 21 indirect taxation acts, those are taken into account for the purpose of this scheme. If demand arises from any of the indirect enactment, enumerated like 21 Act, then if the assessee discloses under the SBL scheme by submitting a form SBLDRS1, that's the application form, and Millards, 50%, up to 50 lakhs, what and up to 50, more than 50 lakhs, designated committee is there to handle their matters. And the pattern of consumer designated committee is also there in the scheme. So here it is above 50 lakhs. Millards, I have made a disclosure, and the disclosure just flows from a show cause notice, which I have annexed Annexed 1, then 16 crores of odd demand is there. Proposed demand is there. And this is also Millards as per section 124 coverable. That is eligibility conduct is not in dispute. Millards. Only question is Millards, I have disclosed I have paid 9 crores amount. Millards, even if the eligibility as per the scheme is not only 50%. The balance Millards, relief adjustment 50% I have to pay. And as per the provision section 124 Millards, and also so far other circulars Millards, any payment made, kindly bear in mind this thing, any payment made during search, seizure, investigation or during pendency of appeal, that will be allowed to be adjusted. And second adjustment, which flows from another notification saying that when money is paid, without any tax paid to input tax credit Millards, that is self credit Millards, even if that is under dispute, supposing I am not eligible to get the credit, or that is under dispute Millards, but that may be dispute under adjudication. But for the limited purpose of getting adjustment under the scheme, Millards, 50% adjustment, which I am otherwise entitled relief, Millards, this disputed self credit will be allowed the adjustment. That is what this 2019, August 2019 circular provides, Millards. Here, what has happened? Here, precisely, so far as the eligibility that is not in dispute, so far as Millards, the 50% relief that is also not in dispute, and I do not have any dispute. Millards. Only thing is, whatever money I have actually paid, both by your cash and self credit. Self credit, as I told you, Millards, even disputed self credit is also eligible for the purpose of the scheme, but the purpose of adjustment, Millards. And so many judgments, even in the case of this petitioner, a judgment of this or no division method is all because now what has done? They say, and my claim of more cash payment, because I say that I have paid only thing, Millards, I say 26 crores I have paid. They say 20 crores you have paid. The differential 6 crores, which are supposed to have been granted adjustment towards the 50% eligibility Millards demand, that has not been granted. And my claim is Millards based upon a RTI revelation, their own verification report department. They have given all details. I have taken to Lordship Millards, and that was not been granted. They have come up with various Millards allegations saying that you have multiple use, so many, without any specific allegation of them. And regarding this 1.68 crores Millards, which I have claimed towards, then this self credit Millards, which they say were not entitled, and that is whether not entitled or entitled, not a question for the purpose of Millards claiming adjustment towards relief under the scheme Millards. That is to be granted adjustment. Because the only CBI circular says that even if it is under dispute, when the money is paid for the purpose of scheme, you are entitled to relief. But basically, two things are there. And I approached your Lordship earlier also. And your Lordship, by next year,
Page 116.
9 and page 116, has passed a judgment with certain specific directions, Millards. I am taking my Lord's attention, relevant page 119, to prevent Millards loss of time, 119. Paragraph 5, Millards. Millards, may I please, Millards, with my Lord's kind permission. Page 119, paragraph 5. Considering pursuant to SCL, petitioner have applied under the scheme, and in view of aforesaid facts, we direct that the personal hearing will be for the purpose of Department of the Designated Committee to conclude on petitioner's assertion that 50% or more of the demand was paid and it is entitled to relief against the balance under the scheme. The Department of the Designated Committee will do well to pass a rigid order such that points all by the petitioner petition and as may or before it. So both, whatever points I have taken writ petition, that is to consider, and such other points which I will pressing will commit also. That's your attention. That may be all before it. Regarding this scheme, applying to it and dealt with without leaving any ambiguity. In the event, the Department of the Designated Committee concludes that petitioner is not entitled to relief under the scheme, it will then issue fresh notice for personal hearing of the demand. we make this direction. Why this your lordship was inclined to pass this direction? Your lordship said, we make this direction in view of clause C in the aforesaid circular dated 27 August 2019 and absence of anything on record or submission made that exercise of reconsideration undertaken in respect of the particulars of the cash payment, which I was just adverting for lordship. That because of the nothing adverse was there on record to have a departure from the claim of the petitioner that in fact this is 26 crores, which is supported by the RTI plus revelation that is given by the department after due verification of all each alert mirrors. And secondly, the very circular, the basis of which mirrors I have relied upon, and Government of India says that even if self is not in dispute, but for the limited purpose of granting adjustment against the eligible amount, 50%, that is to be taken. So in view of these two factors, mirrors, that led your lordship to make a direction to the designated committee to mirrors consider the cases petition. May I explain now after lunch mirrors?
The only dispute is, my lord, whether he has paid that 9 lakhs, 9 crores sum.
He says that he has claimed that particular standard credit.
My lord,
You have doubted it.
that is,
According to him, the circular subsequently issued clearly indicates that even if there is interest in credit under the CF,
not disputed credit, man.
so if that is not for this, yeah.
Sen-
Says that
So far as that send-back credit portion is concerned, that is only 1 crore sum odd, and that part, my lord, not disputed send-back credit, my lord. Disputed send-back credit cannot be adjusted for 3 deposits.
That is the law. That is the circular. That is what I am presuming. I am not saying from present. It's a matter of record. Yes,
Give a circular during the recess.
It is there, annexure, your lordship,
It's a matter of record
21,
only. Yes.
annexure 21,
And so far as
10C.
para 10.
Para 10C.
B.
Para 10C.
I have also one more. You will also come back after lunch.
Go through that.
Will see, my lord, that cannot be a reasonable interpretation. You will also may kindly see 186. Thereafter, my lord, I will give the factual background also. 186, my lord. C. The scheme provides for adjustment of any amount paid as pre-deposit during appellate proceedings. Appellate proceeding or as deposit during inquiry, investigation or audit under section such and such. In certain matters, tax may have been paid by utilizing the input credit and the matter is under dispute.
You are happy at paid.
My lord.
You are happy at the word paid.
My lord. My lord. And this input tax credit, which this send-back credit, my lord, which my learned senior is referring, that is part of the show cause notice. Let me let
Who said no?
And after that,
this provision has been examined by this honorable court, a coordinated bench, and Punjab and Haryana High Court mirrors, Punjab and Haryana High Court, our court mirrors, and other Gujarat High Court. Yes, all high courts unequivocally say one thing, and you lordship will find from paragraph 10 at the earlier paragraph 10. It's a clarificatory clarification by the CBI issuers. Further, paragraph 10. Further, the following issues are clarified in the context of the various provisions of Finance Act and rules made there. It's a clarification. And why clarifying? What is the provision says? It provision speaks the list. The scheme provides for adjustment of any amount paid as pre-deposit during appellate proceeding or as deposit during inquiry, investigation, audit. That is under section 124(2) and 132 reference. In certain matters, tax may have been paid by utilizing input credit and the matter is under dispute. In such cases, the tax already paid through input credit shall be adjusted by the designated committee at the time of determination of the final amount payable under the scheme. So this determination of final amount under the scheme is ASP LDR 3 years.
The reason for which your application is electronic?
But yes,
By not adjusting.
they have not adjusted. Even if tax is paid in respect of Senbat credit which I have paid 1 crore 68 bills, and those are under dispute because as per the show cause notice,
It's a part of the show cause notice. Let me clarify.
I am clarifying. Why you will clarify? You are honorable court asked you to clarify only on 1.6 crores. Sir, I have not gone to the other aspect.
No.
I have not gone to other aspect. Sorry, I am
All right. I'm sorry. So.
So what is here? So far as 1 crore 68 lakhs minor is concerned with us, tax is paid through Senbat credit. And those are disputed by the department in the show cause notice saying that you are not eligible to avail Senbat credit. And the list CBIC wanted to clarify here is that only for the limited purpose of availing deduction from the eligible amount below, this is allowed as adjustment. Maybe this is under dispute so far as the adjudication procedure is concerned, you may not be entitled to credit below. But fact remains money is paid.
No,
And
once it is decided,
minus.
suppose this scheme, under this scheme, for this particular period, the entire payable amount is decided and you pay it, then there is no question of again revival of that.
Correct, absolutely correct.
Suppose,
Correct.
suppose tomorrow, in the ultimate, when you will be pursuing your remedy regarding disputed tax.
No, because section 122 has attached finality once SBI and 4 issue.
So what happens to this disputed?
Dispute comes to an end. That is the legacy dispute scheme, Milord. Your WhatsApp query is very correct. Milord, source is immaterial.
That once you say that the moment the adjustment is done,
Done.
then this dispute
Comes to an end.
balances.
Exactly.
Balances.
Yes.
But that means the show cause notice, whatever they have issued.
It goes.
That lapses.
Yes.
It cannot.
And cottage is down. That is the legacy scheme, Milord. Your Lordship is right in saying so.
Resolutions.
And the intention behind is one might not have discharged his liability correctly under the act. But once somebody discloses on the scheme and
It is not tantamount to stealing a march over the legitimate claim made by the department.
Yes, department itself on his own volition has waived up its liability under the scheme, Milord.
It's an amnesty scheme.
Well, this is one. The second apprehension, my friend was.
Has to be read in a more pragmatic manner.
Absolutely.
And it is a beneficial scheme for the assessee. Then the interpretation has to be done in the favor of the assessee, not in the favor of the.
The what?
I have a submission, my lord. It is a concession, my lord.
No.
In a charging section, when you are not, a charging section is interpreted, the beneficial interpretation is there, my lord. But in a concession, my lord, that will be interpreted in my favor. That is my sub.
You are perhaps arguing in the light of
Yes,
Kumar,
my lord.
Dilip and Kumar.
My lord, in a concessionary provision, my lord, it is a concession.
I think with my Lord's permission, two parallel saying
This is a beneficial piece of scheme. Once it is a beneficial piece of scheme, then there are a category of judgments in there, and how the interpretation has to be.
In a taxing statute,
I am reading from the circular itself, paragraph 2 and 3.
Page 183.
Page 183. Page 183. Just one. Page 183. as may be appreciated, page 189.
Yes.
Paragraph 2, as may be appreciated, the scheme is a bold endeavor to unload the baggage relating to legacy taxes, that is central excise and service tax, that have been subsumed under GST and allow business to make a new beginning and focus on GST. Therefore, it is incumbent upon all officers and staff of CBIC to partner with the trade and industry to make this scheme a grand success. Next, dispute resolution and amnesty are the two components of this scheme, which I want to lay emphasis what my friend is saying concession. Dispute resolution and amnesty are two components of this scheme. The dispute resolution component is aimed at liquidating the legacy cases locked up in litigation at various forums, whereas the amnesty component gives an opportunity to those who have failed to correctly discharge their tax liability to pay the tax dues. As may be seen, this scheme offers substantial relief to the taxpayers and others who may potentially avail it. Moreover, the scheme also focuses on the small taxpayers, as will be evident from the fact that the extent of relief provided is higher in respect of cases involving lesser duty. Small taxpayers generally are expected to face the. So this is the aims and objective of the Minot scheme, broadly, and this is a comment of India surplus. So now the other aspect which my friend was apprehending, that this is only part of that 9 crore, 16 crore, 50% is 8 crore somewhat. Initially, I said that I have paid 9 crore somewhat. Then I rectified saying that only requirement, my obligation to satisfy that 50% is required to be paid. Whereas I modified my claim because initially what happened, whereas what is not taken into account is would have been taken into consideration, the balance would have been only 60 lakhs, which I have already intimated in writing, because now I could not have paid unless they open portal for me to enable me to pay 60 lakhs. That is the point where I stay, Milots. I am agreeable to pay the balance also, because the 6 crores amount, which is the difference between the 26 crores which I claim and 20 crores which they accept. Balance. Yes.
In that also.
So, our cash payment is concerned.
And misdeclaration amounts to have fatal impact on this scheme also. The scheme itself says, it is an amnesty scheme, any misdeclaration would have a fatal and admittedly they have misdeclared their input credit.
So no, yes, misdeclared. I accept it's not. Even though
you have in their application, they have said amount is 9 crores somewhat. Subsequently, it is reduced to 8 crores.
And you have power to rectify. Why don't you understand section 128 and all that?
Wrong declaration with an intent to gain. That the Mensria is one of the important vessels. If they have said that I have paid excess,
correct.
Though under the scheme I'm liable to pay less. Does it make a wrong declaration in this regard? I'm just asking you this question. Whenever the fraud kind of elements are coming, the one of the facets is that what is the gain they had? If they make a false declaration that I am claiming these, and my amount is only 7 crores, I am paying a 7 crores, not entitled to pay 8 crores and up. I would have appreciated what you say that they wanted to gain by not paying the rest of the amount.
My lord, that Mensria part is not there in the scheme also, and it is a.
I'm again when you talk about the wrong declaration,
because that
wrong declaration of that magnanimity that he has gained by making certain wrong declaration. What is the gain he has?
In order to evade or
that is
willfully knowing to the
that is what he has paid more than what he is supposed to pay under the amnesty scheme.
No, my lord, not paid.
That cannot be said to be a wrong declaration.
May I clarify some facts, my lord? Let me clarify. 2 lines, my lord. You lot may permit me 2 lines. I will clarify, my lord. Only 2 lines, my lord. 3 lines, my lord. Here, my lord, the so-called notice has been issued. I am clarifying, my lord. For service tax amounting to 14 crores somewhat, and Senvat credit amounting wrong amendment of Senvat credit amounting to 1 crore 68 lakh somewhat, and total comes to 16 crores 15 lakhs 777.
So he says that.
No, again.
We take a half of it. So it will.
Your lordship, thereafter your lordship.
Subsequently modified. I said no, 9 point is erroneous claim somehow, and it is 8 point somewhat, and 60 lakhs balance I am ready to pay.
With that what I have. Yes. Let me clarify. One line. Your lordship may kindly see annexure 4, his application. His application, your lordship, amnesty application, your lordship may kindly see annexure 4. What he has said. He has applied amount he has reflected 16 crores 50 lakh 77,000. It is right. Thereafter, your lordship may kindly see the pre-deposit column. Pre-deposit of any duty deposit, your lordship. That is 9 crores. And for this 9 crores, he has, for this 9 crores 96 lakhs or more, he has not supplied any challenge, my lord. That is the finding of the fact. Why are you disturbing me? I am not disturbing. I am submitting before the court. I am just clarifying, my lord. What my record says, my lord.
What your authority says that.
Authority, yes, my lord.
Deposited 9 crores.
Yes. Your lordship may kindly see annexure 167.
What they say.
167. No, my lord. 167. Page 167.
What they say.
166 it starts. 166 column 6 point number 6, verification of payments made to challenge claimed to have been paid by the applicant, and the finding is that 167
Kindly place 6.1.
6.1 I am placing.
Yes.
A letter by such and such was issued to the jurisdictional officer to verify and report the veracity of the declaration made under SVLDRS 1 dated bearing ete. In reply, the jurisdictional officer had letter dated ete inter alia reported that based on an affidavit dated such and such made by the applicant and the photocopies of the challenge produced by the applicant, total service tax etiki during financial etiki is 26 crores 5 lakhs 13,836. But the jurisdictional authority could not find and report any payment documents through which such payment of declared pre-deposit of 9 crores 96 lakh 73,534 has been made. With this background, your lordship may kindly come to.
Please, then eventually on the basis of the submission, personal hearing, a letter to the jurisdiction of the such and such was made. In the said letter, the jurisdictional authority has categorically requested to verify the following aspect. Whether this has been declared by such and such is correct or not.
Yes.
Not to what extent.
Yes, my lord, what is the finding, your lordship?
In written list of.
Yes.
Specifically demand copy of the informations. In response, the jurisdictional is submitted. After verification, it is found that such and such was neither made nor indicated that all the challan reflected such and such returns have been considered in the subject as CN dated such and such, and there is no extra payment against the demand.
This is the
count. Yes. This is the they have not paid.
Now,
what amount he has paid that has taken note in the so-called notice.
Now let me say, because I have to substantiate whether 26 crores is at all paid or which you claim
we are now concerned with this 9 crores 96 lakhs which he has declared as
9 crores 99 you cannot, because even if I have mentioned, you cannot even expect me to substantiate 9.9 because 50% as per the statute, and I am obliged to pay is only 50% disputed agreement. Merely because I will say 10 crore I have paid, you cannot demand a such to substantiate 10 crore. That is not requirement of law. The requirement of law is I have to say that 50% of the tax which is to be granted relief and balance I have to pay, for which you have to up. And the provision of rule says, rule 6 says that you have to verify all records, including the details of payment which the assessee has furnished. And after considering all those under rule 6, you have to give particulars of the amount which the assessee is required to pay. It may be little less or more. And in many cases, honorable court has directed us to pay the balance within a certain time. And that those are the requirement of law. You cannot expect me to pay 9.9.
No, we are not expecting. And this amount
but I have
the so-called notice.
My
so-called
notice
was under amnesty and it was reduced to 50%. Again, then that amount will be adjusted.
Annexure 11 is the answer to what my friend wants from me. Annexure 11 at page 1, it starts from page 122. And this is the hearing record. precise hearing record which is noted by the Honorable Principal Commissioner at page 122. What I have given, what evidence I have adduced in support of payments which I am claiming to have made.
They are adjusted in the so called notice. That is the case.
That no, you tell us where it is adjusted. I will show where it is not adjusted, and you substantiate where it is adjusted. Let that be decided. And you went on alleging generic claims to have taken multiple credit, as if I am a thief. And all the periods you have mentioned, we are only concerned with 2013-14. And instead of considering 13-14 claim, you have referred to 10 other SBI claims. You have made 10-20 applications, some are rejected, some are. How do they relevant? I don't understand. We are only concerned in this application, minus only 13-14. And the order which is imputed for lordship bearers takes care of 20 applications for different periods.
No, that was
And with generic allegations, as if payment made once for 13-14 can never be adjusted against any other period. That's the basic requirement of law. It can never be adjusted against any other period. These are each are it's a matter of record department. 1 rupee cannot be taken away from one account to adjust against other. And you may go and wait and wait. I have gone through order bureaus at least several times. And what shocks me is the manner it is written, unnecessarily expanding the scope of the order to the extent not required under law. It's a kind of HSS order.
Each and every point has been.
And my lord's earlier direction in the writ petition has never been considered. Specifically, direction my lord's have done.
Yes.
So, let me take my Lord's attention.
They are more perturbed in your prevaricating the stand at the different stages of the proceeding.
Minus. Yes, I understand. So far as the amount of payment is concerned, the initial claim of payment will not so much bother my lords because it's more than 80%. So normally, the statute mirrors expects me to substantiate payment up to 50% only mirrors. But even if somebody makes over and above 50%, but law neither mandates him to comply to that mirror, nor it is expected that one should pay more, even single rupee more than 50% mirrors. Because it is the obligation to comply 50%. 50% reliefs to be granted and 50% to be paid mirrors. And those are to examine. The scheme of law requires the resident committee to examine the payment, particular payment under Rule 6 mirrors. If in the case after verification of records in the department, it says record will be verified along with the claim of payment which I make mirrors. Those are all to be verified mirrors. After verification, if the outcome is either positive or negative, in the case it is positive, the statute requires it not to be refunded. Suppose more amount I have paid, it is ultimately found, then the excess money is not to be refunded. That is what the law requires. If there is any shortfall, then mirrors in the SBI the 3 mirrors, that is to be rectified amount is to be intimated, requiring the petitioner to pay the amount within 30 days mirrors. So, from the very beginning, my lords will find when I made an application on SBL 1, they issued notice under SBL 2 mirrors. That is the requirement. That's called estimate mirror. In the estimate, what they said that the amount which is required to be paid mirrors that you have not paid. And they for the personal hearing contemplated under 2A mirrors, I asked for hearing, they granted me hearing. And in course of hearing mirrors, I along with the written submission, I made exhaustive mirrors list of challenge, totally 26 crores which I have made as against 20 crores which they have taken into account on the basis of ST3 returns mirrors. And after verification, they say, no, what you have paid, I will take your lordship's relevant portion of the so-called notice, which says that you have paid 20 crores cash payment and 19 crores some odd towards Senvar credit. Out of 99, that is not in dispute grounds. So total they say you have paid 40 crores. In turn, my claim was that I have paid in aggregate Senvar and cash payment 46 crores. So there is a difference of 6 crores. And regarding 6 crores, I have given all details of each challenge along with my written note of submission as against SBLDR 2 mirrors, the estimate which they have given. Mirrors, without considering that, without passing any order, that followed with SBLDR 3 mirrors, which they are supposed to issue after within 60 days. They have passed after 7 days, that I am not on that mirrors, even though limited to that. They say that now you have not paid the amount which you have claimed, 50% you have not paid. You have paid nothing, plus zero. Within the column, payment column, my lord will find zero. My humble submission for lordship is, I might have paid more or less, but it is incumbent upon the resident authority to verify the records under Rule 6 and the details of payment which you asked for, which I have given, to verify all that. And the outcome of verification is to be intimated by a written order, so that if it is positive, negative, accordingly, I have to comply with those. Positive, certainly not. Nothing can be refunded. If it is negative, there is little amount which I am liable to pay. In the case I am liable, So they have not done that. Rather, in paragraph 9, the end of the conclusion of the order, they say you are not eligible. But this is a innocuous finding. Because once somebody says not eligible, that could not have been a case of issuing form SBI 2 and 3. 2 and 3 only arises in a question where a petitioner declarant is eligible to avail exemption. Now the only question left to be decided in all these minutes here is that whether the amount which I claim to have made is actually paid or not. And the amount which they claim to have received, they say nil. Whether nil
It's true. These are all the factual aspects.
Exactly, very correct.
Rich court will go into those nuances or integrity of the fact.
Absolutely correct.
When a fact finding authorities have held that you have not proved or given evidence.
Correct.
So what can,
So now what your lordship belongs, I understand belongs, your lordship correct. So when your lordship can interfere in 226 belongs, there are two things. When the conclusion arrived at by the ladies authority belongs, each based on
perverse
or based on no evidence.
No, that is a perverse.
And third one, when the conclusion so arrived at to a reasonable person, reasonable mind. Yes. Yes. So these three are the only available. Now my humble lordship is, it is perverse based on no evidence reasoning. When I say that's not a matter of one rupee, I say I have paid 26 crores, they say 20 crores. And I will substantiate from the order improved order passed by the regional authority that it is not how 20 is wrong and how 26 is correct. That I will substantiate on the face of it. Your lordship international, because my lord cannot certainly stoop down to examine the addition or correctness. That my lord cannot. I cannot pray for or your lordship, and I can expect my lords. So the face of it I will show you. One. Number two, so far as 1.68 crores is concerned, not only they have said
that since it is disputed in the SCM, rejected, so he will not take this particular amount into account. And they have straight away went forward and discarded. No difficulty. They say SCM dispute, we will not take it.
So now the question is whether discarding this disputed semi credit.
Now you are talking about 10C.
10C. Not only 10C, Milord, a coordinate bench of this Honorable Court has also allowed, and Honorable Punjab and Haryana High Court, three judgments are also there. Yes. And against my lord, this Honorable judgment, they have got a self matter is pending there. No stay of my lord's judgment. So now, whatever money is there, you cannot say zero payment. So that is not free deposit, not zero payment. So payment you have shown zero.
Same
It could not be adjusted.
Same
Because I think there is some actual
tax
misunderstanding.
Let my lord see has the judgment.
Zero payment means
Let
what?
my lord see. Thank you. It cannot be zero. You also please go through judgment.
Yes, also. How the tribunal may judge. It is binding on us.
So they can't say zero. In SBI LDRS, your lordship found, they said 50% eligible amount and you have paid zero. At least 1.68 crores. But with this, I am saying, number one. Number two, after this, because if your lordship permits. Regarding the other one, 6 crores. Because. On the face of it, let me show to my lords. Sorry, bhai. My lords will kindly turn to me, lords. Paragraph 7.5 of the order. At page 169. It has also been observed that the designated committee held SV LDRS 2B dated 8/2/20 granted personal hearing to the applicant on 17/2/20. Sri SP Rai, General Manager Accounts of OSL, appeared on scheduled date and submitted that they have been issued a SCN for 16 crores 15 lakh 77 for the period 2013-14. Mrs. OSL further stated that the instant SCN was issued with a wrong calculation, so much so payment of rupees 20 crores 26 lakh 2292 was considered by the department, whereas the applicant had paid rupees 26 crore 13 lakhs 58 129 in cash and rupees 1 crore 68 23 066 standard credit. However, the applicant did, now he says again 996, which I am not claiming. The applicant did not and could not submit proof of payment of 996. I could not. I am not also. I am only claiming this 6 crore.
Declared amount.
Just a minute. 6 crore and 1.68. And while claiming so, out of 8 crore, I want to pay 60 lakhs. That is precise case mirrors. Now you are also kindly see what payment I have made. Annexure 11 at page mirrors 122. Annexure 11. This is the record of PH. And this is the document. Let me take my lord's attention to the records, the payment details, then I will come back to 122 bills. My lords may kindly, for a moment, turn to page 130, where I have given modified calculation. Page 130, my lords, for a while. Para 19. Tax dues as per SCL, which is subject matter of the present SBI bills, 16 crore 57,792. 50% relief under section 124 is 8 crores 7 lakhs also, and tax liability 50% the same amount, 8 crores 7 lakhs 18. Less amount paid not considered in SBLD as 2 and 3. Where one is differential amount as per RTI verification report, 5 crores 78, 84, 447. Not exactly 6 crores, this is 570. Selvat not considered, 1 crore 68. Total minor comes to apparently at the face of 7 crore 47 0745. Balance tax to be paid as per provisions of SBL 19 60 lakhs 81,531. Then what I have mentioned with a prayer request that therefore the aforesaid fact and figure the amount of cash and credit aggregating to 5 crore 78 so also paid by the notice and judgment dated 24/10/24, which your lordship just looking at. Sorry, the earlier judgment of your lordship bills. 24/10/24 passed by Honorable Orissa High Court may be taken into consideration, and accordingly, a fresh SBI fee issued in the interest of justice. That is that I have prayed for. Now, regarding to substantiate by payment, whether I have paid in fact this 26 crores or 20 crores, I will take my lord's attention to RTI report which I have prayed for and they have given at page 132, my lords. Page 132, the document I have given. The report in respect of the first ARN, your lordship may kindly skip, that is for different period. Your lordship is concerned with LD 241219000846. This is for this period 2013-14. Your lordship is concerned in this petition. Sabka Business Legal Dispute Scale. This is a communication between Deepa Sarana Saha, CGS Central Excise to the Joint Commission Designated Committee. Designated Committee might have solicited report and she has given report to Designated Committee. What is mentioned? Please refer to headquarter office letter number so and so, dated 25/6/20 on the above subject. As directed, the desired report as verified by the superintendent GST Katak 6 range, Katak, with the available record is forwarded herewith for your kind perusal, please. So this verification report will be verified. My lords will find next page, paragraph 2 at the bottom. In compliance with the above, statement as called for by letter so and so is forwarded herewith annexure A for necessary action taken. The year-wise Selvat credit utilized by OSL from 2004 to 2010, your lordship not concerned, and 2013-14, my lordship concerned, has been taken from the statement declared by them and annexure B. Now, my lordship kindly overcome the next page that your lordship will find annexure A. Annexure A, my lordship kindly see, financial year, at the bottom, there are two tables, my lord. The bottom table is relevant for us. We are 2013-14 financial year, said to have been paid in cash as found from photocopy journal produced 26 crores 05 lakhs 13,839. Said to have been paid through Selvat credit declared by OSL 1 crore 98 lakhs. 19 crore 81 lakhs 50,705. Total payment is 45 crores 86 lakhs 64,544. In lieu of 45 lakh crores, they have taken into account 40 crores. Before I take your lordship's attention to 20 crores instead of 26 crores, so my lordship kindly see the next page. 135.
For a moment,
Yes, all challan details are there. Legal is and it contains
1314.
yes, 1314. Date of deposit, challenge number, amount.
Focus notice also. Your lordship may kindly see the remark column. Remark column. This amount, it is not disputed.
Yes,
They have paid. And
if it
they
is
have
not
been
disputed,
taken. No. Yes,
I'm happy.
No, that is the finding of
Not
fact.
disputed, I'm happy.
It has been taken note.
No, not taken that. I'm showing that. Frankly, wait, sir. I'm showing to my lord.
It's part of the focus notice. What he has
That is the
trying
case.
to impress your lordship, my lord. The Senvat credit, which is the part of this so-called notice, which has been reduced by in the amnesty, again the very Senvat credit amount he is trying to utilize it to payment that
That should
reduced
understand where I
Senvat
stand
credit.
now. It's a dispute. I have the responsibility.
Because these
my lord.
challan,
Wait, kindly
yeah,
wait, please.
it has been taken note of in the that so-called notice. My lord, this part, my lord, even my lord, in the launch hour, I have taken advice of my learned senior Mr. Tara. And this, my lord, if your lordship will see,
What you have to say about
my lord,
this is a coordinate-based decision.
My lord,
It is not binding on
that,
us.
that, at best, my lord, it will relate to 1 crore somewhat. But my lord, a very reasonable, can it be a reasonable interpretation?
I can't, when we take, then we are referring the matter to a larger.
My lord,
But then he is entitled to a protection.
with all due respect, my lord, even I am confused, my lord. Can it be,
Hey,
1 minute.
Are you confused on a proposition?
Because, my lord, can it be reasonably interpreted
I am
and
asking you.
irregularly upheld?
I am asking you, sir, whatever the right, wrong, incorrect, bad, in coordinate-based decision is referred to us. If we do not agree, then the only course open to us is to refer the matter to a larger bench. We can't take a dissenting view in this regard and say that this judgment is bad. That is what the Supreme Court in checking out decisions have had.
But is there, but
Even right from community of Daudi Bora till now the 2023-24 judgment. So we are, as a coordinate bench, we are bound by it. Now, that is what we are saying, that we may not agree. There is a freedom which is given. But we have to refer the matter to a larger bench.
my lord, one thing, my lord, one small thing, sir. Can it be, my lord, an irregularly availed Senvat credit?
Sir, show us the law. Had you been in this position, what you will do if this judgment is cited to you? Either show me a contrary judgment of a Supreme Court, show me a contrary judgment of an earlier period, show me a contrary judgment of the special bench.
Then, my lord, I have to
You have to show.
My lord, then next Thursday,
What next Thursday?
Because, my lord, this I was
You know the law, you are talking about this, can it be believed? Even if we say cannot be believed, but we have to refer the matter to a larger.
The review has gone to Supreme Court, my lord. SLP is pending. No stay of my lord's judgment.
Admitted, notice is issued.
Only notice is issued. As a matter of fact, no stay, notice issued.
So there is a line of judgment that
my lord, that part I cannot
if there is no stay, the legal.
Even, my lord, on the face of that clarificatory circular, my lord, it also, my lord, I for the past.
Can you argue? I'm asking you. We accept your contention and refer the matter to a larger. We are referring, if you want.
That will only impact to only 1 crore somewhat, that not much.
For the balance, I am addressing. Kindly wait. Now, my lords may kindly turn to lords, page 54 for the balance. Just one, I will take 2 minutes.
The balance is 6 crore.
6 crore, yes.
87.
5 crore. 6 crore, but excise precise.
You want to deposit.
No, I want to pay deposit 60 lakhs only because the balance only.
As per page 130.
I have shown my readiness all along because starting from the beginning. But the page 54 you also can. My friend says that it has been taken care of in so-called notice. Just please bear with person.
That is the fact.
Did not take cognizance of this judgment, which is pronounced in November 2024. And I think your
a copy given to them, matter of record, their record.
This judgment was given to them.
Yes, yes. Answer is yes. They don't bother me also. Yes,
this
one
type of statement.
There is no, I do not find any reference of this judgment in the.
What I'm surprised. I'm just asking him.
And when it is given, let me also show to my lords. And it's 11 record the head. So, judgment.
11.
No, how come you are authority
Yeah.
in respect of the same party? And show cause notice is also earlier to this show cause.
Same
Here-
period,
here
both
it
the
is,
same
uh,
period. Lordship.
Here it
Show
is
cause same.
15th October
13, 14 is a-
2015.
This circular, my lord, this part, my lord, this part, my lord, I am also.
Yes, sir.
My lord, this part, I cannot, I have no argument on that. That, my lord.
Propriety.
Yes, my lord, I got your,
Propriety.
yeah, I got your lordship point, my lord. Whether it has.
How could he avoid this in respect of the same party? Had it been other parties not reported, but it is AFR and judgment pronounced in open court? Must have been. And the standing counsel appeared. The same counsel. How could it be? That means department.
No, my lord, this is not like whether it has been produced before the department.
No,
or not,
no.
that part, my lord, I have.
Where you have produced.
Not recorded, Lordship. It is not recorded. Not in. I have filed in course of the hearing. I have
After what appeared and given.
No, that I have seen the same.
No, you should have, you might have given in on a memo or.
Along with the written note of submission.
It's handed over your.
Written note of submission. You have given.
It is not there. I've checked up, Your Lordship. It is not stated.
No, written note you have given.
Yes, Your Lordship. It
Then
is
you have referred to this.
no. I'm checking. No.
But she said that she was at the time of oral hearing, I have kind of.
Yes, sir.
And in this way, we will take benefit on benefit. Because that part,
That is different.
because that part is the part of the so-called notice. Under amnesty, it is reduced to 50%. At that very amount, he is utilized to payment at 50% only. That is the case.
Maybe.
And another thing, my lord, since your lordship had taken note of that misdeclaration, if your lordship will permit me, I will take your lordship to that rule. That rule which says misdeclaration would have a fatal impact. What a minute, sir, I have as it is, I am feeling nervous standing beside my senior. And such type of interference makes me more nervous, man.
It cannot never be, no.
Your lordship may see 86. In case of voluntary disclosure, where any material particular furnished in the declaration is subsequently found to be false within a period of 1 year of issue of discharge certificate, even after adjudication, it shall be presumed as if the declaration was never made and proceeding under the applicable indirect tax enactment shall be instituted. That is not applicable.
It's a,
Yes, your own case is that you have misdeclared that.
not, I have again said, it's 9 crore, I am not on that. I have diverted and you
That is your
have
declaration and subsequently it has been reduced. That is a misdeclaration.
cannot be misdeclaration.
This judgment, my lord, this judgment I have to be, I am not a fast reader at all, my lord, I have to go through my, and,
Say that.
and,
I actually what they say.
yes, my lord, even I have, when I have, I am also, when I have saw that circular, clarificatory circular, my lord, I have taken the assistance of my learned senior Mr. Kaur. He is also, how could it be illegally availed send-back credit could be accounted for? That is, cannot be, my lord.
Illegally availed tax.
Irregularly availed, at least irregularly.
You have said under dispute. What is the meaning? What other meaning can be assigned to that word under dispute? Give me any hypothetical example that will show that what was the mindset behind the incorporation of those.
That under
Understand? Tell me what is the effect of this word under dispute? What would be an under dispute and what would not come under dispute?
that under this.
I have seen Orissa Sales Tax Act and Orissa VAT Act. there is what is disputed, that is defined. Is it defined here? Under dispute.
It is, that is the statute.
Give me a hypothetical example. Let me understand that this will be under dispute and others will not come under dispute.
My lord, that part I am also, I have to take instruction because my lord.
Sir, any amount which the department says that you are not entitled is under dispute.
My lord,
It becomes a dispute. And the moment it becomes a dispute, then in that event, it has to be given effect to in that way. Whether it is consignable, it is not, this is up to the authorities to ponder upon and reframe or rephrase those provisions. So long that provision continues and the ambiguity cannot be attached to it, then what remains?
My lord, so far as that engraftment of that under dispute portion, my lord, whether it relates to this SENVAT credit availment or something else, my lord, I am also, I am from the very first, when your lordship, I have started my argument, my lord, I have submitted, my lord, there is some gray area, my lord, I cannot, there is no second opinion, because that, if your lordship will again see that clarificatory circular, it is merely a clarificatory circular only.
If in other ways, clarificatory circular is binding on, not binding on my lords,
clarificatory circular.
Binding on their own officers.
Yes.
Sir, I do not know the 15. If you read again, it also talks about in certain matters, the tax may have been paid by utilizing the input credit.
Yes.
And the matter is under dispute. You say whether it applies to SENVAT credit, it does not apply. What is the input credit? Where a person can take an input credit? Pre-GST regime. Let me understand. Give me.
They have a set of rules, SENVAT credit rules.
That is there.
So input credit, SENVAT credit, they cannot say no.
Yes, that cannot be. But this clarificatory circular.
I'm asking.
Yes, I understand.
Input
Then
credit.
whether it will apply or it
Correct.
will not apply. I gave him that this word is also used. What does it mean? Tell me.
Input tax credit, man, it is availed by the
No,
manufacturer.
under what? Under what circumstances? In what cases? What should be
If the raw
mechanism?
material is taxable and the final product is also taxable, on the raw material he will get the credit and
How?
it will be
Under what?
there is a
Under what? Under what?
there is a rule,
Under
my
what?
lord. There is a rule, my lord.
Hmm,
Earlier it was SENVAT credit rules
correct. So
only to
if it is input credit means a SENVAT credit, then it is only to neutralize.
Yes.
Just to avoid a double taxation.
Yes, to reduce the cascading
Or
effect
a
of tax.
multiple
Yes.
taxation.
My lord.
If it is to neutralize, this is the purpose by which the neutralization can be achieved. This person cannot.
Yes.
So,
yes. Intention to reduce the cascading effect of tax. That I cannot include. And this impute credit,
we don't accept.
it also relates to SENVAT credit. That cannot also I cannot say.
But you are saying whether
whether
applies
it
to SENVAT credit or
No,
not.
my
Let
lord.
me see. Let me think about
lord,
it. I
these-
talk to my senior, Mr. Mishra. What are you talking? No. You can't argue in this fashion.
This is how it was earlier to this petition was filed. This one.
Earlier to
Annexure
this-
9.
Yes.
Annexure 9.
Yes, Your Lordship.
The same.
Yes, absolutely yes. Annexure 9 is only belongs dated.
Another
October
show.
Yes, Your Lordship. Another show.
Another show. Against that earlier 23rd October 24 one order.
Yes, Your Lordship. That was set aside.
That is period 13-14.
13-14. Only, that is the only period.
So
13.
here.
The one here,
13-14.
13, part of it.
Oh.
10-11 to 13-14.
This emanates from this slot.
Yes, yes.
So judgment of 10-11.
So, it is very clearly stated, come to page 118. It points out, it points out from clause C and para 10, that even disputed amount of survey credit is to be adjusted under this scheme.
Yes,
The clause.
this is the whole 9 crores and all big things.
Yes.
This is the Dutch.
So then C was quoted. Thereafter, this court directed you to reconcile,
Yes, ma'am.
right?
Yes.
Then he has come now. That means you have never considered this order also. As if it is what to say about paragraph 5? Has your authority taken this?
So also reconciliation.
If
Para
also
five.
to
Not done.
one thing, he has not followed this judgment in respect of the same party and direction of this court in the same case.
That is also there.
Then the next page, Annex 10. The reference,
Yes, ma'am.
Honorable High Court of Orissa, order dated so and so, 23rd October. Then he mentions it, he gives a notice, then publics.
No, my lord. Thereafter this.
Now, thereafter this, then what has it done? Written note, circular is enclosed.
He has coined a very interesting word. That amount is challenged in SCM. Avoided the word dispute. Very interesting.
Page 127, para 13. Written note.
Yes, ma'am.
Acted para 5 of this
Yes.
direction. Then the reconciliation statement. No, not this.
The talent.
Then para 15, the reconciliation statement or claim statement, whatever.
This 26 crores. This
Then
is
refer to 10C in para 17. Para 19. Made a calculation.
His part is there, but can he take benefit on benefit, my lord? Since the so-cause notice is reduced to.
Why this is amnesty?
Yes,
FAQ may
and
also
only
can-
one benefit he will take, and which is the part of the so-cause notice again that memo on that disputed amount, it took the.
180.
FAQ may also kindly see the frequent asked question Government of India. FAQ at paragraph 18 minutes. That's all. The doubt, this is only for you or no doubt. Frequently asked questions. But the question is what is the answer of the Government of India? These are standard answers notified by the government. On a very lucid language, I have already paid duty oblique tax by utilizing the input credit and the battery order dispute. Will this duty tax already paid to input credit be adjusted against my duty tax liability calculated under the scheme? That is a question here. And the answer, Government of India says yes. In such cases, any duty tax already paid to input credit shall be adjusted by the regional committee at the time of determination of final amount payable on the notified officials. Question number 52. Issue, just let me wait 54 minutes. For a while, because wait 54 minutes. Like, just only one thing I want to point out for my lord's reference only, so that it be clear. 54 minutes, just one.
So there is a clarity in your mind.
Mind.
There is a clarity in the mind of
Absolutely.
bench also.
Yes, ma'am.
I would say the obscurity in the mind of Mr. Pusti. So let us decide what we do.
And let me repeat my humble submission. I am agreeable to pay 60 lakhs gross. That is the differential amount which I am supposed to pay towards 50% line. And there are several judgments.
Item number 36.
Very, in item 36, your lordships, to be very fair, your lordships, I need another week's time to prepare for this matter. A very complex issue involved in this matter, wherein I'm challengingly giving effect order based on the judgment passed by the Honorable Supreme Court. It relates to the 148 proceedings of the old regime and the new regime. So the interplay of Ashish Agarwal and Rajiv Bansal has a bearing. Yes, after 5 years, they have done this, giving effect to the Rajiv Bansal's order. So how much it is applicable to my case, I need some time to prepare. Not already. The lordships, with your permission, it can be on 5th. Just a week thereafter.
Week after.
2 weeks. Obligation. Yes.
37.
Next, all the judgments, TOLA, notification, everything.
My lord, sir, I was 27, I've been instructed to file a counter as there was some time will be granted, I'll file the counter.
Why you did not manage?
The last week,
Instruction was last occasion.
and has passed orders without taking note of, the collectors and commissioners' recommendation and
That effect, I found, file a counter bringing on.
nothing has been written.
My that's in the.
What, you have got the instruction?
I was,
It will be a, it will grant you, but it will be a very mandatory. How soon you can?
As 2
No,
weeks.
no extension. Under no circumstances.
2 weeks. Then my that's 3 weeks.
It is peremptory.
Peremptory is mandatory. Or
Unless it's a.
that's the timeline is peremptory and mandatory.
Yes, madam, it's also a new subject area for me, so in order to also.
Yes, yes.
So that
We appreciate
that,
taken assistance.
that's why I'm requesting 3 weeks. But I can also give my best to the counter.
Got any inputs
And that's, I've
from your
read,
department? Got.
and that's not,
Yes, she is just a newcomer.
Yes, yes, yes.
She has not realized the functioning of the ground as of now.
I did read the file, on a lighter note, my lord, the concept kept bouncing off my head, I tried.
Ensure that within 3 weeks it is done. No, it's
You brought outlines so that she can
Yes.
comprehend and draft.
But
But we are member of the bar, she wanted to prepare herself, why not? 3 weeks, that's a big one. 3 wonder you want to prepare?
I
1 week.
4 weeks.
actually no course, I think. I mean,
What is the?
they have demanded more.
It's been added to the excise duty.
That is one of the ground also, but other ground also they have not. Yes, ad valorem landing costs.
Excise.
That is not an excise duty, that is my sub. That is also not a dealt with by this on court, I'll cite also.
That is not a excise.
No,
Actually, excise.
because section 29 says excise duty or countervailing duty. Other duty.
Clause 3.1.4, it will be specific component plus ad valorem component.
Can you do it if the statute does not include any kind of a duty to be imposed? Can you impose it by virtue thereof? Are you not supposed to amend the rule or the act?
This is the policy.
Is a charging, like a charging provision?
Policy cannot override policy, excise policy. Yes,
2020.
policy.
Because you have mentioned that ad valorem 1% of landing cost.
Yes.
Landing cost means
The
transportation.
yes,
From
yes.
OSPC.
OSPC.
From OSPC to your.
Yes, Lord. Because here I have shortfall, so I have not lifted. So the question of landing cost also doesn't arise. Landing cost arises when I lift the quantity, then they charge that. Here it's a case is not shortfall. It's COVID period. During COVID, there is a shop was closed and they have lot of restriction made. Saturday, Sunday closed.
Beneficial use of patients. That was extra charge.
Yes. They have made 50% extra. MRP was increased to more than 50. 100 rupees has been given to 150 at that time.
It was.
To curtail the sale of liquor during COVID.
To some person, it was more beneficial.
No, it is closed. Not beneficial to the licensee, not.
Definitely,
because
Why already lifted the entire.
no, they charge the duty. That 50% MRP which they have taken from the license.
No.
On the stock which are available with me.
That was.
Yes, Lordship. That also they have taken.
Differential amount they.
Yes, Lordship. First they have taken.
50 rupees.
Yes, Lordship. Yes.
Or a duty on 50 rupees.
But if it is not cost, if it's 100 rupees, then it was increased to 150.
Great.
Yes.
Then
So it is a duty and cost.
It at
Both.
150.
Yes, Lordship.
So the 50 rupees margin you got it.
No, that margin they have taken.
What
State has taken. State has taken from
Entire
that.
50.
Yes, Lordship. That is extraordinary. Lordship.
Yes.
Yeah, Mulad, I have prayed for carry forward of that only, because now also I am licensed.
Debatable, madam. This point is debatable.
That is an order. There is an order in the, because there are 3 cases. In one cases order has been passed. They have not filed counter to that order. Where ad valorem part has been discussed. Yes, sir. Yes.
Under the policy.
Yes, sir. Police cannot override the law. Law itself.
No, policy has to be there, but in accordance with the policy, certain amendments have to be brought.
Yes, sir. There is no amendment in the law.
Delegated power or statute provides.
Excise Act or the rules provide for any kind of a policy.
No, Miller. That is also Talent Act and rules doesn't say that the government can frame excise policy
Provides for
of
issues
provisions of any.
circulars and the notifications under the Excise Act.
No, nothing. No. But they're doing, there is a precedent every year that way.
No, it's just policy is a difference. Talking about notifications.
Notification is there. That is there. Right. Rule making power is there. They can make rule.
Madam, what to do?
Because I'll examine Monday.
But
Within 3 weeks, sir.
that will give, but he is asking for no coercive step to be taken.
And it's if I may make a suggestion that instead of coercive step, minus some amount can be deposited with the registrar judicious, that in case he wins the case, that can be refunded to him. And if he doesn't, then the amount can come to the state.
A bad suggestion?
There is no liabilities there.
No,
Because Lord, I have another prayer here. I want their carry forward of that shortfall NGQ, because I am now presently also I am licensee. So that collector amount is
2 lakhs,
yes.
42,000 and all.
No.
2020.
2021. During that period, Sunday, Saturday, they close. Saturday, Sunday. They reduce 50% of the sale hour. That is also contrary to the law they have made. So, Lord, here I have prayed.
Extraordinary circumstances requires an extraordinary decision to be taken.
Not that we have accepted, but let them. That's why I have said let them carry forward, because I am now also present license. some license I have. So I may be allowed that to leave that shortfall. That also I've said, and commission has granted. Under Annexure 14, commission has granted. That's why there is a recommendation. Collector and commission has recommended that's it. So government has not taken care of that.
In most of the cases, permitting them to lift the shortfall.
Yes,
at this point.
They'll get the revenue. Present revenue they'll get.
That means the government does not lose the revenue.
Yes.
After all, he is still a licensee, he is entitled to sell.
Because there's also this thing that from one shop, the licensee cannot lift the with regards to another shop.
That is the commission order, Annexure 14, or kind of glance, page 67. I've given that to him. There he has granted. One shop defaulter, another shop is has been allowed by the commission of excise.
Just imagine, what is this MGQ? Is a minimum, it's not maximum. If it is a minimum that every year you have to at least lift this much of quantity. There is no outer cap. If the demand comes and if the sale is there, they can definitely buy the more amount, more quantity.
Yes.
So if this will be treated as a more quantity to be another one, then they are bound to lift it as an NGQ.
No, if it is permitted, also I'll pay the duty of the current year. They are charging duty of 2021. Now I'll pay the current duty if I'll be allowed to leave. That has been rejected. Though there is a recommendation of the collector and commissioner, that has not been considered. Those two documents has not been whispered in the input order.
Let us take a decision for the next week. Yes. We are adjourning it, take a decision.
Yes.
We do not want to impose something on you. Have our consultations with your authority, with your seniors, and come back.
After 3 weeks, ma'am.
No, interim order, they go 2 weeks.
Yes.
Next week.
No, that happened also during pendency of this. Collector
No,
again
this has been
recommended.
pending for pretty long time.
Yes,
This is a one
yes,
thing
sir.
is nothing to going to happen.
That's it.
Yes. From next week.
Just comprehend the issue and can draft the relevant.
You people have to take care of those juniors. She candidly said that all these issues are bouncing above her head.
That is, she has gone to the ad valorem part, that's it.
Yes, ma'am. Yes.
That's why I have not argued with regard to ad valorem blending cost. If it is not, I may permit it, then I'll pay the entire excise duty. Current duty also.
Yes.
Ma'am.
Next week. This.
Item-
Instruction. Slide on my.
Item 38.
In this case, yesterday I have received all the counter filed by the state. So I want a week time to file my response.
Hard copies are not on record and supplying the hard.
Take it out before.
Yes.
Before submission that it has been served yesterday.
Item 39.
What are these matters, sir?
Regarding the charge of royalty on processed food money. On processing of the food.
Millard, I am appearing through VC. Can your lordships hear me?
We are for Mahanadi Coalfield, sir.
Yes, Millard, I am.
Opposite party.
Yes, Millard, I was praying that if your lordship can keep this matter on the 5th of February.
In fact, matter was
Oh,
voted on Monday. My lord.
He was.
I had mentioned this matter. If your lordship will recollect, this matter was mentioned of your lordship.
That is another
If your
matter.
lordship,
No, same,
This is-
same matter.
same matter, my lord.
On the-
Item 40.
Lordship is the petitioner is challenging the order passed by the computer leader of the register under Annexure 6 in TMC case number. Lordship, kindly have a glance at Annexure 6 last order,
Page.
page 34. Final order.
Just one. Yes.
May I permit you to? What has happened? This is the second journey of the petitioner, Your Lordship. On the earlier occasion, Your Lordship, with 51 penalty under the rule 51 of OMMC rule, Your Lordship, a penalty notice has been issued to the petitioner. Your Lordship, without giving any opportunity. Thereafter, the petitioner,
Notice, does it
Yes.
require an opportunity?
Your Lordship,
A notice has to be issued unilaterally by them so that it will reach to you, then an opportunity to defend.
Your Lordship, that amount has been finalized. That
Where is the
amount of
notice?
Your Lordship, earlier, Your Lordship, kindly have a glance to the annexer.
Notice is issued without giving an opportunity.
Annexer 1, Your Lordship.
I can't read.
ଆପଣ ନୋଟିସ୍ ପ୍ରାପ୍ତିର 7 ଦିନ ମଧ୍ୟରେ ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରୀଙ୍କ କାର୍ଯ୍ୟାଳୟରେ ଉପସ୍ଥିତ ହୋଇ ଉକ୍ତ ଦେୟ ପଇଠ କରିବେ, ନଚେତ ଆପଣଙ୍କ ବିରୋଧରେ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ କରାଯିବ, ଇନିସିଏଟ୍ କରାଯିବ। ଆପଣ ଦେବେ ତ ଦେବେ, ନହେଲେ ରିପ୍ଲାଇ ଦେଇଥାନ୍ତୁ।
Annexer 2, Your Lordship, kindly. Again, they increase that amount, penalty amount, from 4 lakh to 6 lakh. 6,64,000.
Still 7 days time was given.
Yes, Your Lordship. Thereafter, the petitioner approves this honorable court in annex under annexer 3. Such order has been filed because there is an appellate authority to appeal before the sub-collector. Thereafter,
So this notice was challenged in the writ petition.
Yes, Your Lordship.
This is seizure.
No, stacking of the buzzery and all, everything.
Yes, Your Lordship.
That is the case.
Concern. Lordship, thereafter, the liberty has been granted by this honorable court. The petitioner thereafter approached to the
file an appeal.
Yes, Your Lordship. The sub-collector dismissed that appeal. Thereafter, in second appeal, the petitioner approached the
collector. What is the ground on which it is dismissed?
Ground that the petitioner is not pursuing this case, Your Lordship.
No, that is not good.
Last line.
Page
27.
Page 20, what is that? Perusing the appeal memo and documents available therein.
Yes, Your Lordship. That is in pursuance to the order of this honorable court. But this matter has been taken up by the sub-collector. Thereafter, the final order has been passed, dismissal order.
27.
Page 27. Okay. Where the Lawrence sub-collector dismissed this appeal due to non-pursuance of this case.
So dismissed for default. Then
thereafter, the petitioner approached to the collector in second appeal. Annexer 5.
Yes.
The Lawrence collector remit back to the Tahsildar again. Your Lordship, last paragraph.
No difficulty. Then
thereafter, Your Lordship, for re-inquiry and retrial of this matter, Your Lordship. However, the Tahsildar, from the last record, Your Lordship, without any re-inquiry, making any re-inquiry, with that same report, they have passed such order and initiated, and last line, if Your Lordship kindly have a glance, in the last line that the certificate case has already been initiated. Therefore, Your Lordship kindly have a glance.
So go for a second appeal as you did in the earlier occasion.
What has happened?
Go for a second appeal. Why you are jumping the forum? Once before you exhausted a remedy by approaching the second appellate forum, then this time why you are bypassing the second appellate forum and approaching us?
Because they have passed the same order.
Whatever, then the same result will be there by the second appellate forum. He set aside the order and remitted the matter. So they will take care of this. We will. No,
certificate case
sorry, we can't say. There is an alternative. This resolution is there.
Yes,
where is the OMMC rules? which is the provision for second appeal.
Basing upon this order, your option first appeal first line before the sub collector. Second appeal is before the collector.
Where do I get it? Which provision is there?
Not only certificate case, that is not only the ground.
That
The
is the
merit also.
observation. That is the observation we can't.
Further on verification of the case, as per the order of the so certificate case has.
46.
46 is the.
46 is the first appeal. Is a order of the competent authority. Oh, it is a competent authority.
Yes, sir.
Oh, yes, 46. You'll have to go to the collector. Good.
Meantime, such certificate case will not be proceeded with the election, otherwise the petitioner will be remedial.
You have a different avenues there. Under the Public Demand and Recovery Act, I believe so. There is a different scenario. The channelization is different. Go there.
Section.
Go there under.
Same order has been passed by.
Sorry, this is under a different. You go maybe.
If this
We are
subordinate
taking up
authority
this.
has not carried out the orders of the higher authority, you have to go before the higher authority only. We cannot execute, we cannot make subordinate authority to execute the orders of higher authority. That is what.
The challenge is made to an order dated 16
authorities prior to the amendment 2022. Now, after the amendment, it is the mining officer and deputy director mines. Your Lordship may kindly see 46. So the three amended bill because
I will rephrase it. Instead of the district, the collector or district magistrate, the second appellate authority, the word to be used. That will do. Second appellate authority.
deputy director. Deputy director.
We are not going to say that. I have the understanding of law may be wrong. If a court has disposed of the matter, refusing to entertain, I think the court does not retain a power to protect the parties by way of an interim order. My understanding of law is that the interim orders are passed by the court in aid of the final relief, so that the parties to the proceeding cannot alter their position, nor they can frustrate the object or the issues. I do not know. If you can show me a law, I will be definitely benefited by that. That if a court declines to entertain the writ petition and say dismiss the writ petition or disposal, yet the court passes an interim order to operate beyond that dismissal. I want to learn. My learning is bad, so I want to just learn. You correct me. My mind is open. I'll correct myself.
Item 40, the connected one.
So connected matter arising out of same, the connected matter is okay. There is another.
Is another matter.
Yes, sir.
Same order.
Then arising out of same appeal, but case number different. In the second appeal, there is another 3 matters that have been taken into consideration by the collector.
Oh, so this one is what? 18 or 17? 18. What about 19?
19 not.
Parties have not approached you.
Item 41.
My lord, the petitioners are the bidders of for the sand quarry matters, sand quarry beds of the Loisik RA circle, and the opposite party number 5. The private opposite party is the successful bidder for the session of 2020 to 2025. My lord, during that period, for the period of 5 years, my lord, during that period, my lord, he has been served notice of illegal mining and illegal extraction of sand, and has been fined.
This is opposite party.
Yes, my lord.
Yes.
Annexure to, my lord, TR number 2506 of 25.
So he has been fined. Then what?
My lord, he was fined since 2022 because of as it has been referred in the office letter dated 9.
No, this is the order of 2024.
It has been fined since 2022. It's still pending. My lord, the parties, along with the residents of the village, have approached the authorities, the Tahsildar and the collector, and as well as the Deputy Director Mining Sambalpur Circle, my lord. But for requesting for cancellation of the lease deed, and
Now lease has expired, 25 has gone. You have entered into 26.
Yes, my lord. But they are still continuing as per my recent instructions.
Sir, we can't.
Also,
say.
this this is this honorable court's judgment, writ petition 20652, my lord, is one of the, in the annexure 2, there are 3 persons who have been listed, named. The third person, Ashish Yadav, is the brother of the present opposite party number 5, against in favor of whom this writ petition was passed. As he is not a successful bidder, he should not be imposed fine. Using this as a shield, they are still continuing to mine, my lord, and till now the Tahsildar has not issued for a notice for a fresh lease of that sand bed, and opposite party number 5 continues to mine, my lord. This
Yes, after the expiry of the period, how can you, is there any clause for a renewal or extension of time? In the rules?
So environment, first of all, the demand of the
Forget about the demand. We are not concerned with the demand. It is up to you. It appears that this lease was for a period of 5 years, commencing from 2020 and expiring in 2025. So 2025, it has already expired. If the lease has expired, how can he continue?
environment, the lease was again, the mining plan has been approved for 5 years, my lords. Then,
From which date?
the date of execution of the lease.
When the lease deed was executed?
that instruction I'll take, my lords.
Then what I think the petition might have been served in the office much earlier. How can you permit a person whose tenure has expired to continue digging or making a sand quarry? Yes?
My lord, this is the order passed in August, my lord. And in this, my lord, if I may, the relevant paragraph.
You have already said that here this particular matter relates to an unsuccessful quarry bidder who was not awarded a quarry permit.
He is, my lord, he is the brother of the successful bidder.
So if a brother has committed a sin, then another brother should be prosecuted.
No.
Is this a law?
No.
Tell me.
I'm not on that, my lord. May I humbly request to kindly refer to.
Why you are saying taking this brother? Whoever has committed a wrong, he will be prosecuted.
My lord, in that order you have reflected in para 8, my lord, he for directing the authorities to check if such violations are still going on, my lord. After that also, my lord.
So this is what we are asking.
Yes,
so far as the imposition of penalty, we are not concerned for the timing. That is what they have to take. But what about the mining activities continuing? Quarry activities continuing? Madam, how can it be? If you cannot resist, we are which place?
Loising, that is Loising, Jharsuguda.
So we are sending our one of the officer as advocate as there and just to go and find out. He will go discreetly. He will go any day and then find out.
There, as per the instruction.
That shows the another facet that the mining activities are going on, but not illegally. Then whom you have given a mining or this quarry? How far it is from here, Katak?
350 kilometers.
6.
No difficulty. Any person of that locality? You are sending. You will not do it, let the court see. If the illegal mining activities are going on or quarry activities, the court will not shut its eyes. Sorry.
You are not from that, Mr. Agarwal? You are from that side, I think.
From Kalahandi.
Kalahandi also.
Kissing allocation, kissing that, wishing that. Jharsuguda district.
Jharsuguda.
Yes, Kalahandi is from Western Orissa.
ଆପଣ ଅଛନ୍ତି ସେଠି
Malagiri.
ଆପଣ ରାଉରକେଲା ଆପଣ ରାଉରକେଲା
ସମ୍ବଲପୁର ଚଳି
ନାଇଁ ସିଏ ଅଛନ୍ତି ରାଉରକେଲା
very close ସମ୍ବଲପୁର
ଯିବେ ଲୋସିଙ୍ଗା
Huh? And anybody from Jharsuguda?
Jharsuguda can I be? Nobody.
No, he is from Raurkela, I think.
Jharsuguda was.
Jharsuguda is 90 kilometers away.
If we are in the prior to this, yes, this is
Yes, madam. And the government will pay his remuneration.
I confirm if any lease has been executed or not. That one chance may be given.
These cannot be executed. There must be a auction. There must be some kind of a tender to be floated. Is there any provision under the Act for renewal? Under the OMMC rules? I don't think so. After the auction regime came, I believe it should be more open, transparent, fair. Only we are concerned that how he is continuing with the query or lifting of a sand.
Read just 3 lines from the instructions I'm also forwarding.
Yes.
It says that the mining plan has been approved by letter number 1/12/22 for 5 years, which may be modified after lease agreement annual rate of replenishment study after 1 year of quarry operation.
So every year you wanted to do a study. So when the lease was executed or agreement was executed?
He got this on 2020 by letter dated 27 July 2020 of Tehsildar Jharsuguda. And then due to delay in obtaining the EC, the lease agreement could not be executed on time.
So that means then it is still continuing. If it is from the date of an execution, then it is for 5 years from that. So it will be ending in 27.
Yes, ma'am. So then I confirm my just one.
Then she's correct. If it is from the date of the execution, if the execution is 2022, then in that event 5 years have to be computed therefrom.
If the execution, if allowed, my lord, if the execution was in 2022, my lord, then immediately the penalty was how then?
That penalty you are not concerned. It is up to him. Don't think they know their exchequer how to take care of. Don't come.
Illegal demand was caused by this court's order on 22nd August 2025.
This demand.
Yes, madam. The
So-
illegal demand of 1 crore was quashed.
That is the order, my lord, I have given, my lord.
So that has been caused. Then how can
That
we
has been
recover?
quashed against the brother of the
If the entire demand is caused, then what remains? If it is relatable to 3 persons,
specifically caused and in paragraph 7 specifically against the petitioner who is the brother of the successful bidder, my lord. That is all.
they are not operating according to you because you have not executed the lease deed as of now.
That's what I'm saying. Mining is going on there at the moment.
So there is no mining activities which are going on.
There are.
No.
The mining officer visited that area, and then thereafter it was informed that no mining is going on in that area from 24 to 25. It's mentioned in the last paragraph.
If it is going on, can't you take some kind of an evidence?
Yes,
Produce the evidence without which we can't. You have to. This cannot be done in this way. Stop. The
Item number 42.
My lords, well, lordships, they will into the legal application. We like to start this in it's like different manner. Relying upon your lordship's own judgment, this is a lift irrigation case. By placing a particular paragraph in that, my lords, I'll be, since I've premised my case on your lordship's observation there, I would like to just read out that particular paragraph. During the simple citation, I'll just confine my initial permission to that only. Lordship has page 53 of that operation I gave it. I'll just place that. Paragraph 5.5. Where an error is far from self-evident, it ceases to be an apparent error. Once a mistake on face of the record is established, what order should follow to correct that mistake should always depend on the fact, circumstances required to rectify the mistake. Now, this is the part. If the mistake is one which requires determination of some undecided issue, because it has not been decided no days, the procedure would follow the discovery of such mistake to recall the order and decide the case afresh, or to decide that issue after affording the opportunity of hearing the parties concerned and pass fresh order in light of the finding. My lords, my submission before lordship is two vital aspects. In fact, my case before lordship was that the guidelines which the government family welfare department has laid down has not been complied with. And secondly, my lords, my point before lordship was there was a proceeding in the tender committee meeting where they have come up with a calculation which in fact favors my submission that they have not fixed up this criteria, eligibility criteria in accordance with the guidelines. Now, my case before lordship is the state jacket judgments of the Honorable Supreme Court with regard to tendering authority having jurisdiction to fix up the tender conditions. This case was out of that bracket because these are cases where the guidelines are.
I think there is another observation this court has said that mistake must be of such nature which does not require any second thought or to be gathered from the voluminous papers to be gone into in this aspect. What it is sought to be contended in that is the author is the best person to interpret. Is that the party should not be prejudiced by an act of the court or a mistake committed by the court. I believe the actus curiae nonninem gravabit is the legal principles which has to be borne in mind. It has also been held that the review cannot be permitted to rehear the matter, to revisit the judgment, and to rewrite the judgment in the manner as ought to have been written. The thing is that one has to understand from a case to case what is there. If the omission has resulted into a grave injustice or would tilt the result to just diametrically opposite to what has been there, such omission, if it is apparent on the face of the record, may at times be considered, but not in that way. If you wanted that these 2 points are to be decided, but it will not disturb the very fabric of the ultimate decision, I believe the review cannot be invoked in this regard. I think that has also been held there. No.
Because there is also an additional affidavit which your lordship is not.
Maybe that does not mean if the fringe materials are not there. That does not mean that the court will just go by the diktat of the pleadings. Every one statement which is made there has to be reflected in the order. No. It is the issue the court will just address, and whatever is the material the court finds has to do it on that.
I bowed down to that.
And I think this has gone to Supreme Court.
So, no, he is
No,
counsel.
main matter.
No, main matter is, he is the counsel.
No, main matter has gone there. I believe so.
No. Not gone to Supreme.
At least I don't have the instruction, but I don't think so, because they have given me the order to file the civil.
No.
My only submission to your lordship was, since these are cost-based fixed tenders, since the government has already fixed up a particular rate, hence these turnover clauses which they are fixing are beyond the mandate of that guideline. Madam.
So that we have already held so far as the guidelines are concerned. I think it is better because this cannot be reopened in this way. You don't think so? I am bound by my own other judgments as well.
Bound of your lordship.
I am on that.
My sincere endeavor before lordship.
I think there is another division bench judgment earlier which I have authored. They are in another court as well.
My only effort before your lordship was.
And I have already indicated.
My only endeavor before your lordship is that the typical or the judgments which are in fact applicable where the tendering authority has jurisdiction is not applicable to this particular case because these are fixed cost-based tenders, my lords.
No, that may be then it is erroneous judgment actually. If it is it's an erroneous judgment, and there is a line of distinction between an erroneous judgment and a judgment which contains an error apparent on the face of the issue. Erroneous, go higher up. Only review is.
Have your lordship read that additional affidavit?
No, it is already there.
That point, my lord.
No.
Because
very difficult.
One more line, my lords. In fact, that additional affidavit reveals that previously, because of this guideline, they amended the wrong turnover, high turnover clause and brought it down, my lords. So that is the similar, exactly same pleadings are before your lordship. That in this case also, they should have amended that.
That is up to this. We do not find that the argument was on the basis of a level playing field. We have also considered everything that we say.
Your lordship sees in para 14 of the rate application, my lord. That was my point, my lords.
Sorry. So that has been dealt with by us, I believe.
My most humble submission, my lords, my point number 4 has not been.
This is Vikram. In the instant case, before the finalization of terms and conditions incorporated, proposed pre-bid meeting was there, suggestions were and objections were invited, several intending participants, including you, their authority, which is the expert body, justified the fixation of the turnover, given as a reason that the nature of the service ordained the seamless supply of the foods to the indoor patients for 2 or 3 months
that point, two aspects, my lords.
Correct. The financial capacity for uninterrupted supplies to be rendered to the price clearly discernible, and therefore it does not offend a level playing field.
First, they could not have done that. Because
that is we say that they are the best person to do it. If they have imposed, we do not find any arbitrariness in the.
There is a principle that a fountain cannot rise above the source, my lords.
That's true. And this is why 14 says the surface court to ascertain the arbitrariness in the action of the administrative authority is whether the condition imposed in the tender have any nexus to the object sought to be achieved, eradicating the vice of arbitrariness or unfair treatment among the eligible candidates. Then 15 was observed that yes, there appears to be a reasonability in the same. No, sir, it's not difficult.
In fact, I've prepared one page. Lordship gives me under 2 minutes. I'll just demonstrate your lordship, just 2 minutes. I'll just take 2 minutes. I can lordship had a look at that point number 4. Then much more easier, my lord. The lordship looks at the top, my lords. Previous RPF, this is all part of the records, my lords. Tender notice was called in 1612. It goes slowly, my lords. Initially, the above RPF dated 16/12/2020. The clauses were as follows. Clause 2.2, turnover was 6 crores. Clause 2.4, above 12 crores.
Sir, previously they fixed at the lower price. That does not mean that in the next, that is what the spirit of the judgment is. That why in a pre-bid meeting, objections and suggestions in this regard were not accepted by the authorities, and why they fixed it.
That's a very reason, because there's a resolution under which the diet rate.
That we do not. That we do not.
May I place, madam? General diet rate for that period was.
You said that if that being the position, how can one achieve this much of turnover? Your argument was also there.
My submission is they cannot exceed a particular limit of turnover as per the guidelines, my lords. They have to stay by that.
That is
that.
What I'm trying to demonstrate before your lordship is.
Has it got any statutory force guidelines?
That guideline-
Or it is merely an executive instruction?
Under Annexure 2, they issue it by way of a guideline notification.
That's not there. Guidelines must be of such nature which is legally enforceable by a third party.
By this, what happens, my lords? The Family Welfare Department fixes up a guideline. Now, if one.
This is how they have to follow. This is a statutory or executive instructions. But again, I'm saying if it has got no statutory force, if it is merely an executive document, third party cannot come forward and say legally enforceable document.
Once what happens is it opens the floodgates for other agencies throughout the state to create a monopoly kind of situation.
You go there, still you have the avenues to go there. Go there.
Lordship,
Go there.
place the entire thing, if we come to your lordship.
We'll decide the scope of the review. Decide the scope of it.
They are given.
Review cannot be done in this way.
As your lordship has made compilation.
We'll consider. We don't forget to deal with.
Page 2 of that index, if your lordship has looked at, given those judgments in that context.
Yes, we will definitely consider. And Tungabhadra of the old judgment of the 5-judge bench will also be taken into. Have you included Tungabhadra's judgment here?
I have kept it confined to the aspects where courts have interfered, including your lordship's.
But you should also produce where court has refused to interfere. No, I have this one as well. No difficulty.
They have also dealt with on the last occasion when I mentioned before your lordship had said that subsequently your lordship had passed an order referring to my judgment. The sports judgment. That also I've stated, I have framed a proposition for your lordship's consideration.
We have referred to in one only.
So Tungabhadra 1964.
Irrigation.
Yes, that is referred.
Yes.
5.14.
Yes.
Quotation. Then Ashok the dictum is reiterated in pursuing the.
Yes, we will consider this.
Then very conservative.
And I believe the review to a review order is not permissible under the law. It will be adjusted. Tomorrow, definitely the Friday. No, tomorrow is the holiday, sorry. So next week it will be adjusted like this.